Two defendants, two motions to dismiss, one statute called strong medicine, and one filing mistake that could cost Karen Read everything. This is Defense Diaries. Let's dig in. Good morning, Vietnam. This is Defense Diaries. I'm Bob Motter, your host. And as always, I am joined by my beautiful and brilliant co-host, Allie. What's up, girl?
Hey, babe.
Looking
hey, all.
foxy today, girl. Looking foxy today.
You mentioned that, and I'm like, oh, there's a little cleavage.
Yeah,
Gotta
little
fix
cleaves.
Gotta fix it.
Leave it to Cleaver.
We'll move this up, actually.
Wow.
There we go.
All right. So what's up? What do you want to do?
I mean, a lot.
We just hanging? Yeah, there's a bunch of shit up.
So here's what we're going to do today. We're not going to read all of the Karen Read's motion to dismiss and the Shoulda-Been-Suspects response. We're gonna explain to you where everything's at because their reply, Karen Read's reply, is due today. And we'll talk about what we hope and expect that it's going to do and some other things. And then we're going to read Aidan's motion to dismiss and the opposition to that.
Ops is
we are gonna break it all down. So I mean, I think we got to start with the email debacle and the judge's whole orders coming down saying, hey, y'all got to tell me what's going on with these emails. So
wait, so before we do that, because I agree, like in terms of substance, that's good. But let's just talk about the elephant in the room. Karen Read's attorney's fucked up. Plain and simple.
So here's what happened. And it's very clear. There's no ifs, there's no ands, and there's no buts. The complaint was filed in April. All right. They had a briefing schedule where their motion to dismiss was due June 18th. On June 5th, they amended their complaint. And nobody on Karen Read's team must have told the guy that drafted their motion to dismiss, because their motion to dismiss specifically and only replied to the original complaint, which is no longer in effect.
Did you see the memo on the TPS reports? Kind of that kind of shit. Because this dude did not get the memo.
Right. And then Karen, and then the Shoulda-Been-House-Suspects played some games. They threw around some empty threats about default. And when we get into these emails, we'll get into it more to explain why it's an empty threat and all of that. But it all starts with, and we went over it the other day, so maybe that's the best place to start.
I'm sorry to interrupt you, honey, because I am looking at the chat. Background, when we're talking about, remember, this is for the defamation case. So let's start there, because there are a lot of cases going on here. So these motions to dismiss are dealing specifically with the defamation case against Aidan Kearney and Karen Read, brought by the Shoulda-Been-Suspects. Okay. So that's what we're dealing with. And what happened is that the Shoulda-Been-Suspects amended their complaint. They are the plaintiff in that claim. And Karen and Aidan are the defendants. Just so we're clear, because Julie Jensen was asking who amended the complaint. There could be people that aren't up to speed on what's what. So hopefully that kind of gives you the framework.
No, and we, Julie, completely appreciate your question, because sometimes things like go over our heads as far as something that might need to be better explained to you guys, because we're kind of, we've got
and sometimes I think we assume that everybody just knows everything, and you know what they say about assuming things.
Definitely makes an ass out of you.
Yeah, for sure. Oh, sorry. Wow, that was probably loud.
That was a lot. That was a lot.
That was my jackass noise, and it's spot on. Like
All
all
right.
of my impressions are. Come on, let's go. All right, roll.
All
Sorry.
right. So no problem. So I'm gonna actually start with. Sorry, I've changed course. I'm going to start with where I thought. So give them a little background on where we're going, because we're going to start with those emails, and I'm going to pull them up while you're doing that.
All right. So essentially what we're going to do, okay, as Ali said, we're going to basically summarize Karen's motion to dismiss. You guys are going to get to hear a lot of petitioning activity from Ali today. You can hear probably more of it when we get to Aidan's motion to dismiss, which is a very strong motion to dismiss. You're going to see what it should have looked like from Karen's perspective, and it's different arguments in terms of what constitutes petitioning activity. So it's really interesting. But in terms of Karen's, we're going to give you kind of the high notes, the low notes, and what we think can still be done and should be done by Karen's attorneys. Because look, this hearing is looming. It's like it's up next week. We're going to give you what we think, if we were the attorneys handling it, if we had made the boo-boo, what we would do. That doesn't mean that that's what Karen's lawyers are going to do. And I saw some tweets or comments to my post earlier about them shitting the bed, and they did shit the bed. Like if
but we don't think it's a death knell, and we'll explain why.
If you're right, but if you're looking for a channel that is Karen Read's attorneys can do no wrong, and that ain't us. We're always going to call balls and strikes, and they shit the bed on this.
This is a strike,
like
a big one.
You what, if I'm Karen Read, I'm fucking pissed.
I am screaming and telling them, you better throw yourselves on the sword. Request leave to file an amendment.
You're giving up the whole end game on that.
All right. So let's start with this. Yesterday, okay, the judge in Karen Read defamation case ordered the lawyer for the Shoulda-Been-Suspects, the one suing her, to explain under oath what was missing from his own sworn filing. So that's like the headline as far as I'm concerned. But the real story is how we got to that point, because behind those orders is a 2-week email war that started with a genuine mistake. I mean, a huge mistake, and an undeniable kerfuckle of the highest order by Karen Read's lawyers.
Kerfuckle of the highest order.
Escalated with a default. That's my empty threat that was dead on arrival, and ended with the judge deciding to ask his own questions. So, babe, to understand, well, why don't you tell him, and I'll pull up the emails. So to understand why the judge did what he did this week, you have to go back to June 18th, to the email that nobody thought twice about. So first step, the Shoulda-Been-House-Suspects obviously sued Karen and Aidan for defamation back in April, as I said. The amended complaint, June 5th. The amended complaint is the only one that matters. It is the lawsuit. Under the briefing schedule the parties worked out with the court, that's when her motion to dismiss was due. And on June 18th, let me share my screen. We're going to go through these now.
Yeah, because we got clarity finally as to what the hell that mysterious order that we were all wondering what the hell the judge was talking about. Now we have the clarity for it.
Right.
And these are the emails that were the impetus of that particular order from the judge.
Correct. So I'm going to have to look at my screen, so you'll have to pay attention to all the other things, babe, so that I can actually see. Because even if I had my cheaters on, I couldn't see that. So on June 18th at 7:05 p.m., which tells you that their filing deadline is midnight, or 11:59.
Right. Because it's either close of business, which for most courts and clerks' offices is 4:30. It's not 5. It's usually 4:30 because, government jobs are cushy like that. Or it's 11:59 p.m.
So in most places, filing, actually the e-filing of something, the submitting to the court, you've got until 11:59.
Yeah.
but service to the other side, which is under their rules. That's why it's kind of weird. It's like under their rules, their, filing deadline is really just service to the other side. So that must also, which typically is 5 o'clock, so, or 4:30 if you're dealing with like the state's attorneys, or as Bob said, those cushy jobs people. But clearly it's not an issue. So in any event, Thursday, June 18th, 7:05 from Damon Seligson.
Seligson. Yeah.
Sorry, guys. Who is...
It's all good, babe. We don't owe Seligson jack shit. I mean, people mispronounce my name all the time. So
I know, Moda. Stop it.
Exactly.
So just, he's sending an email to all the other lawyers. Counsel, pursuant to Superior Court Rule 9A, attached, please find defendant Karen Read's motion to dismiss. Under separate email, I am sending a share file that contains the exhibits attached to the affidavit. Kindly provide us with your opposition within the applicable time period. Okay? So then what, babe? Nothing happens.
Nothing. Crickets.
For like 5 days.
Crickets. That's what happens. You gotta give me a little heads up and I'll have that sound bite going for you.
So there you go.
Oh yeah.
On June 23rd at 8:27 in the morning. All right. Karen Murphy, the lawyer who now has to explain himself, who also signed this affidavit, sends this email back. He says, counsel, we intend to request for default pursuant to Rule 55A against Karen Read in the defamation action today. Defendant Read appears to have served a motion to dismiss an inoperative pleading related to the closed Barnstable County Superior Court.
Barnstable.
I
learned the hard way on that one.
i.e. the original complaint.
Right.
And therefore failed to respond to the operative allegations in the first amended complaint pending in the Plymouth County Superior Court. For this request, we are not required to confer pursuant to 9C and are able to file this request outside the normal 9A process. However, as a courtesy, we are available for a conference this morning should counsel for Ms. Read prefer to have one prior to our filing. Now, here's why this is their empty threat, calling bullshit all over the Shoulda-Been-House-Suspects lawyer. Default is when you do nothing. Okay, somebody files a complaint against you and you sit around on your hands and you do nothing. If you also don't file your answer timely, then the other side files a motion for default, maybe. And then the lawyer says, sorry, Your Honor, I need another 10 days to file my appearance. If you've been actively defending the case, there's no chance in hell. I mean, it's not even a possibility that you're getting defaulted for what they're calling, a 2-day late, a 3-day late answer, which we'll get to why, because we haven't even gotten to why. And I just want to note, these are emails we are reading right now are those that are attached to the Shoulda-Been-Suspects lawyer's affidavit in opposition to Karen's motion to dismiss. So this is the emails as they presented them. This is the emails that caused the judge to question, and we'll get back, to that. So that's June 23rd, 8:27. Then you have Damon responding at 10:23 a.m. And he says, Karen, we assume your threat below refers to the fact that the caption is from the original case you filed in Barnstable. What is it?
Barnstable.
And that citations are to paragraphs and count numbers in the original complaint. We just discovered both facts after receiving your cryptic message. We'll serve you with a corrected copy by end of day tomorrow, which will fix these errors, but will not substantively change anything. Obviously, Ms. Read has not, quote, failed to plead or otherwise defend as provided by these rules. He's citing to that Rule 55. And any filing or affidavit pursuant to Rule 55 stating otherwise would be blatantly and knowingly false. That part's true. This other thing that that Damon's saying, like, oh, we assume you're talking about the caption. That's just like, that's nothing. We'll fix that. We'll get it to you. Now, I'm just going to take a step back, because if you were with us on our last live, when we got the judge asking about, so there was after these motions were filed, but before they were on the public docket, the judge was like, hey, I need both copies of your June 18th and June 23rd motion to dismiss. And Bob and I were we said, this is speculation time. We're like, this is really weird. We also thought it was weird that he was asking for it in Word, but that's just what this guy does. And I'm sure it's so that he can, copy and paste if he wants, or he can search and it can be more difficult on PDF if you, depending on how old you are, I guess. But in any event, we kept looking at the docket, and we're like, why in the hell would there be a June 18th and a June 23rd? Are they trying to say that they served them on June 18th and then changed it and filed a changed motion? What is going on here? We're talking about how, well, if you're going to change it, you've got to amend it. And I was like, well, and if they did, then why didn't they serve a new notice? Their notice filed on the 23rd, like stamped on the 23rd, says we served our motion to dismiss on June 18th. That was all very weird. And now we're seeing why. And we'll get into further what we think they should have done and why they shouldn't have done it that way. But that's what all that confusion was about in the first place. Like, why is there a June 18th and a June 23rd motion to dismiss when it says it was served on June 18th? How could there be a June 23rd motion to dismiss? Didn't make any sense.
Made no sense. Right. Zero sense.
So then you have Murphy responding. All right. Like an hour later. And it's, Damon, we've not made any threats. I'm simply putting you on notice of our intent to make a filing as a matter of courtesy, that we otherwise do not have any obligation to keep you apprised of under the rules. Your assumption, as you describe it in your email, is incorrect. Saying, oh, it's just the caption and the paragraph numbers are wrong. If the issues with your submission last week were as simple as you described below, we may have been amenable to your request that we accept a late motion. However, they are not. We take it from your response that your client does not wish to avail herself of our offer to conference, and we will proceed accordingly.
Now, let me jump in and ask you a question, my dear.
Yes.
If you were smart, if you were Kieran Murphy, and you saw that they had filed their motion to dismiss and failed to address multiple allegations contained in the new amended complaint, why wouldn't you have just waited and hammered them? Because apparently it slipped under their radar. So you have two choices there. You can say, okay, we're going to do this thing that the judge is never going to grant anyway, or we don't say shit and we let them walk into court on the 14th and we say, well, judge, we have X, Y, and Z allegations, like she's a first degree murderer and they didn't address it. So you go through, like, I just don't get strategically why they didn't just try to hammer them with a shock and awe type campaign on the 14th. Instead, they gave them this heads up, which is going to give them the opportunity, as we're going to discuss later, to fix it.
So, two parts of your answer. One, they had to file their response anyway. So the response would have given them, like their response would have said all of this anyway, as it does, but I think that maybe the reason was, like, I don't want the judge yelling at me saying, why did you, I want to move this quickly. You saw they screwed up. Why didn't you, reach out and say, you guys responded to the wrong complaint? Instead, I'm sitting here dealing with this now. And now we have to extend everything a month and a half off.
Fair.
Is what I'm thinking. So,
and based on what we've seen from Judge Gildea, it's exactly what he would say. So, yes.
Right. But in your typical situation, abso-fucking-lutely. I mean, obviously, I would have had to been in my response, but I would not be giving them a heads. I wouldn't be like, y'all fucked up.
Right.
Never.
Thank you.
Right. I just file my response and see what they did with it, you know. Let them be like, ooh, you know, but it's all in writing and filed, and the world knows they did it, or the judge knows they did it, or, you know, whatever. I would have done what you said.
Yeah.
I would have done what you said.
Yeah. Sneaky. But, you know, and look, I just want to say this on the front end. The thing that makes it inexplicable to me is not that a mistake was made, because lawyers make mistakes. What happened here appears very much to me to be is that you have too many cooks in the kitchen, and they're not all from the same firm. Because when you have multiple firms all kind of chiming in, and you got one lawyer saying, all right, man, look, you're going to handle the motion to dismiss. We trust you on it, whatever. And then the thing slips through the cracks. Like, say, for instance, motion to dismiss guy isn't really aware that the amended complaint existed, even though he would have been copied on it, of course, and given notice as he's attorney of record. But I don't know if he's the guy that gets it from his firm in terms of whoever the actual receiver is. You know what I mean? And because if you've got a large firm and they're serving notice on the firm, like if there's a general email, it may not specifically go to the specific attorney per se, which you would hope that a paralegal or assistant would be like, oh, this amended complaint just came into whoever has been assigned the Read case within that particular larger firm. So to me, it's crazy that it slipped through the cracks through so many lawyers. And I'm
but
trying
if this
to
one
understand
is
why.
signed by Damon himself, so I mean, yeah, it's I guess when you're like the lead, you're not having anybody double check your shit. But wouldn't someone have said to him, hey, dude, an amended complaint came in? Like, that's what doesn't make any sense.
You know what requires somebody to do that is somebody to have actually read his motion to dismiss. And it seems like nobody did that, because they're like, all of these lawyers are accomplished lawyers. They're all very bright lawyers. These aren't like a bunch of bottom feeder lawyers. These guys are, and gals are all very, very smart. They're all very accomplished. It appears to me, and we don't know if Damon actually drafted it, right? We don't know that. It could have been a young lawyer in the firm said, all right, I got a motion to dismiss. You got to prepare. Here you go. Boom, 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 boom. And Damon kind of gives it the once over. He says, good job. Let's fire it out. And I mean, who knows what happened? But the bigger problem is that you have so many lawyers from different firms. It doesn't appear to me that anybody actually read it before it went out. Because if they thought that the caption and the numbering was the only thing wrong with it, that tells you all you need to know. Right? Right. Oh, she was barely paying attention.
No. I didn't know if you guys knew that I got, like, my screen went.
It's like he doesn't swear on his chat. It's a massive fuck up is what it is.
Can you hear me?
Yeah, we can hear you.
Oh, because my like, I thought everybody went out, like, went blank, but my shit went. So I don't know if you heard me saying, Bob, I can't hear you, and then oh shit.
No, okay. Couldn't hear any of that.
Who's BC called it a
brother counsel?
Oh,
yeah. I mean, it is what it is. It is what it is. You know what I mean? It's like as soon as we looked at it, we're like, oh my God, what did they do? So I
kept trying to find some way. I'm like, is this really what happened? Did they actually just respond to the original complaint and then try to fix it by
renumbering and throwing a caption,
the right caption on it?
Right. It's like,
which is what they did.
Yeah,
instead of saying, oh shit, we fucked up, and seeking, fix it. Wouldn't have taken much to fix it, to actually substantively address everything, and then file an amended thing and ask the judge for time. And then that could have piggybacked their other damn motion to continue, but whatever. What's done
Sarah,
is done.
we're going to get to that answer. And
what's your
and
question?
the question is the judge can't work around it. It's really that cut and dry. This thing's
It's
not
not.
dead in the water.
No,
So,
it's absolutely not that cut and dry, and we will get to it.
yes, we'll get to it. We'll get everybody off the ledge by the end of the Karen Read thing. Because remember, we are going to slip into Aidan's motion to dismiss, which is excellent. And that's where we're going to be talking about a lot of petitioning activity, because as it stands right now, Karen's motion to dismiss isn't making it to that stage where you're going to get to the merits.
No.
That's where it's
getting
at right
to the
now.
Merits. It's just not getting to stage 2.
Well, that's to me where the merits are, really.
Well,
that's where you're getting.
All right.
To the
Well, you got to explain that when we get to it. Right.
Yeah.
Okay. So, that was Murphy's email on June 23rd. Then you have at 11:27. Then you have Damon coming right back with a response. Kiernan, we disagree, but let's schedule a call to discuss this. Are you free at 3 p.m. this morning? I don't know what he's saying he disagrees about.
I don't know either.
I don't know what he's saying he disagrees about. He could not have intentionally, there's no way to get around that this is exactly what they're saying happened, but it's also not default. This isn't default world. So Damon sends that at 11:33 a.m. right? Then the next email in here is Damon again at 4:06. So Kieran, as we discussed this afternoon, so they had that conference call at 3:00, I think. So attached is the motion to dismiss and special motion to dismiss with non-substantive changes. So they're saying we didn't change any words. We didn't address anything new. We didn't change anything. So it's still an answer to the first complaint. That simply provides 1, the correct caption of the case, and 2, citations to the correct paragraphs and counts in the first amended complaint. Also attached is an unsigned Word draft that shows the changes in red line.
So if you're Karen Read, this is the email that sets you ablaze. You're like what? Yeah, it's clear on the 23rd of June that still somehow they're blissfully unaware of the fact that the amended complaint contains new allegations.
At least Damon is.
Wait, why do you say Damon's saying we didn't do anything?
Unaware,
substantive?
Blissfully unaware.
Right.
Or either way, he's admitting that he didn't address the amended complaint right here. That none of what I did addressed the amended complaint because all I did is change the caption and make when he says citations to the correct paragraphs, complaints are by 1, 2, 3. You've all seen them. They're always on the screen.
But the point being is that he's sending this thing out, having made those changes, thinking that it was sufficient to handle the issue. So
or knowing it's
Murphy,
insufficient.
I'm sitting there saying, is this guy out of his mind? It's like we have there's new allegations that you have not addressed in any way, shape, or form. So you putting a caption and renumbering it ain't it, buddy. It's
right.
It's crazy. It's crazy.
Okay. So then so then he comes back at another hour later and says the attached was also filed today. But I just want to talk about the word in red line changes. He's saying, and I know it's self-evident, but whenever you can track the changes so that the other side can see without having to do their own, research, and I'm sure they did anyway. They did a comparison, what was changed to make sure there's not one substantive difference. You did not address something that wasn't addressed before. So that's at 5:05. So then you've got at 7:16 p.m. from now Christopher I don't know how to say it. Matei. Aaron. So now he's sending this to Rosenberg. My apologies for a lack of decent reception during our conference. So Rosenberg's like, I'm stepping the fuck in. Damon dropped the ball. And he had some kind of conversation with Matei. I was attempting to respond to your comment that any affidavit submitted in support of a request for default would necessarily be false. I attempted to say and reiterate here that our assessment of Miss Read's motion to dismiss is based on what we believe to be the only rational, good faith reading of your motion, which is that it fails to plead or otherwise defend against the first amended complaint. Those statements are true, but that's not how default is, again, not like you failed to respond to this complaint, which can be grounds for like a motion, but it's really, you're not defending this action. You haven't been involved. You didn't do shit. You blew the deadline to file an amended complaint. I mean, to file your answer to our complaint. So the default threat is empty. That was never going to happen. So returning to the body of the email. That said, we understand your position to be that your motion to dismiss reference to the original action and the numbered counts and paragraphs set in the original complaint were simply mistakes. Not the case. You also conceded that your motion to dismiss does not respond to the new allegations set forth in the first amended complaint, and that you are not and will not be advancing any arguments directed to those allegations. Fuck no. That cannot be what he said. But this guy's just making his little record here. He's throwing out this email and taking what he said, which what he said was, I'm not going to change anything substantively. And Christopher is like, well, you didn't address the amended complaint. So you're basically saying you're not going to direct any arguments towards that. That's not the same thing, for sure. But you have now emailed us an untimely revised motion to dismiss and have filed a notice with the court referencing your June 18 motion, but not what you emailed us today. I find that weird too. I don't know why he did it. He's so worried about this June 18th cutoff that he's not really explaining to the court, what happened. I would have filed a re-notice of motion saying that I served a corrected motion that addressed the caption and the paragraphs numbers and changed nothing substantively on June 23rd, blah, 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 blah. Like, I just would have done that as well. All right. But any event, that's what the thing says next too. In any event, as we consider whether to request default, it would be helpful for you to confirm that Miss Read will not be making any arguments directed to any allegations that were added in the first amended complaint, and that she will move for an extension of time to permit late service of the motion to dismiss emailed to us today and request a corresponding extension of our response until July 13th. If so, this would sufficiently address our concerns. Well, of course it would. So they're saying here, fine, you served it late on us, even though it wasn't really, because it was the same exact one. So I don't know why they would need any more time, but so be it. And we're just asking for the corresponding 8 days, whatever it is, 5 days, to file their response. So let's see how Rosenberg responds. Okay. So he sent it at 7:16 and Rosenberg responds immediately. Chris, it seems you may have misheard part of our conversation. I did not concede anything about what our current motion does or does not refer to or argue. Karen said that your team believes our motion does not adequately address allegations made in the amended version of your pleading. And I said, that's not a basis for default. It's an argument for you to advance in your opposition if you so choose. Very 100% accurate statement thus far. Yes. Nor did I commit to not advancing any arguments. I told you and Kieran, that we would serve a corrected version of our motion. We would not contain any substantive changes and would only change the caption and the paragraph count numbers in our citations, which we have now done in clean and redlined form. So again, Chris is interpreting that as like, all right, so you're not going to advance any arguments on the new shit because the old one didn't advance any arguments on the new shit. But he's not committing that they're never going to attack those because a lot of the arguments they made can be applied to those a little bit. So our Rule 9E notice of motion to dismiss refers to the date and time we served our motion to dismiss, June 18th, and is accurate. You have not requested any extension of time. If you do so, we are happy to consider it. Finally, just to be perfectly clear about your default threat, Rule 55 only applies when a party, quote, fails to plead or otherwise defend. That is patently not the case here. As I said on the phone, I want to avoid this kind of unproductive back and forth between counsel, particularly in filings with the court. They only serve to delay litigation and distract from the substantive issues in the case. Well, of course, you know, the Karen Read's team right now doesn't want this to be highlighted. Like, hey,
they don't want a bunch of law tubers talking about their shit.
Yeah, that's always happening. But at the end of the day, he's right and he's wrong. I mean, the default thing is a non-issue. It's a non-starter. It's a non-winner. And it would be a complete waste of litigation and distract from the substantive issues. He is correct in saying that. But if your team files a pleading or affidavit saying we either failed to plead or otherwise failed to defend, and it would be here or otherwise failed to defend after we 1, appeared in open court, 2, worked with the court to set a briefing schedule, 3, served a motion to dismiss, and then 4, conferred with you about inadvertent errors in that motion, such a filing would necessarily be false. This is the kind of shit you've got to fess it up. You've got to fess it up. Maybe you say something like, I don't know what you say, but you admit it. You admit that you did not realize that the new that the amended that you were only working off of the original complaint and that the amended complaint contained things relevant here. And we'll get into it more after we go through all of this. But
this is like a weird double down. Right. I mean, if you fuck up, sometimes you just got to own it. I mean, no one likes that feeling. Right? Like if you're a lawyer and you've made a mistake, you know, your stomach is in knots. You're like, oh my God. You know, and the problem for these guys, if this is a normal civil action, the eyes of the world aren't on it. The eyes of the world are not reading every pleading. All the law tubers that are following the case aren't going over your gargantuan mistake on lives and doing videos on them. Like that's, you know what I mean? So they need to be hyper aware of the reality that exists around this. They're obviously cognizant of the fact that hundreds of thousands, if not more, people are actively following this case, actively. And for this kind of blunder to happen, you know,
and then
like, sending an email like this, which you know is going to become an exhibit at some point. You know, it's like, just own it early and say, dude, our bad. Like, we got to get this shit right. And Allie's going to talk about, in terms of the timing of it, that date of the filing of the amended complaint matters in terms of their time frame, giving them the ability to make the changes that they need and file their amended motion to dismiss.
They almost would have been better served, in my opinion, to leave it the way it was as an as a motion to dismiss their original thing because the 60-day clock under the rule still applies for everything that was there before. In my opinion, they would have been better served to leave it as it was and then file another motion just attacking the new things, file it quick, and,
which
fess it
they
up.
can still do.
Yeah, I mean, they
They
should have
can
done
still-
it, but they should have done
But
it.
they can still, we're still within the 60-day window.
Well, yeah, but I mean,
look, dude.
right, we're gonna get to that, like
We're gonna
asking
get to
for
it.
leave and requesting it of the judge.
Right. I
but
mean, it's a pain in the
that's
ass.
probably what I would have done is left it.
The only
they
thing
were
that makes it
frantic,
the
it
issue,
sounds
babe,
like.
is that the judge has set the hearing.
Right.
Like, that's what the biggest problem is here.
But you know what? I don't know how they're getting that hearing done. 2 motions to dismiss. You've got Aidan's. So 2 completely separate rounds of lawyers arguing different points because the things against them are different. So they could, it's not like it would be a wasted date. They'd get one resolved. But all right, let's get through this so then we can do all of that.
Despite the look on my face, 2 things can be true. Matei can be a weasel, and Karen's team also fucked up. Both those things could be absolutely true. One of them, because I don't know that dude from a hole in the ground other than his work on the Alex Jones case. One of them for certain is true, and that's Karen's team.
I'm on the phone with Alan Jackson, if I'm Karen Read, saying, all right, this seems to me like they fucked up, and is that what happened here? Like, what's going on? Because she's got to have a certain level of trust with him that he's going to give it to her straight.
And I'm sure that was the exact thing that happened. Like, immediately she's like, Alan, tell me what the hell is going on here. Explain it to me as if I was a 5-year-old, because this shit don't look good. Is it as bad as people are saying? And Alan's going to give her the straight dope. And then Alan is going to be putting in a phone call to a few lawyers on the team and reading them the riot act.
They've got till today to file their response. So I will expect there's going to be some backpedaling from that and some new requests and some new responses. And then the judge, we'll get to it. We'll get to it. All right. So we'll go back to the email. So that was, again, at 7:49 on June 23rd. Then
Babe, do you need a drink? Because I'm going to re-up on my coffee.
No, I've got it. I've got it.
All right, I'll be right back.
And then the next email is the following day. So June 24th at 12:33. And I think this is one of the ones the judge asked for a specific response to, but we'll get to that right after we go through these. So she says, Aaron, based on the language in your 9E motion, which references only the motion served on June 18th. Again, so you've got to send the court notice. Again, the way it works is, and it works like that all the time, except it's not hitting the docket here, is you file something and it hits the docket typically, and you also file notice that says, I gave this to the other side on this date and time. So here, because it's not getting filed, all they do is file, submit to the court, and it hits the docket, the notice that says, I served my complaint on my motion to dismiss on June 18th. So then when you file that 9A package, that June 18th thing better be in it, or both better be in it. And I actually didn't check, and maybe I should have gone back. I thought I checked every version to see if there was one that was dated June 18th and what they filed, because what's on the docket is like 1,000 pages of the same complaint over and over and over again. And I tried to go through them all to see if they also served a June 18th version. And they didn't. So anyway, only references the motion served on June 18th. Can you please clarify which version of the motion to dismiss that Ms. Read intends to ultimately serve in the 9A package? If Ms. Read intends to file only the corrected motion that was served yesterday, plaintiffs intend to file an emergency motion today seeking to strike your Rule 9E notice and to clarify which motion plaintiffs are required to respond to. We are available this afternoon to confer on that emergency motion pursuant to 9C at your convenience. Wait, did I miss one? I did miss one.
Ruh-roh. It might be a shorty.
No, but this one's supposed to come. Oh, it's because they don't. Oh, okay. Okay, I know why. All right. So then he responds. Aaron responds a couple minutes later, 12:48, and he says, Kieran, your email omits from the chain my conversation with Chris last night on this topic. I've pasted that conversation below your message from today. And that's where we get this thing that just says from Chris. Aaron, this is a disappointing response and a mischaracterization of what transpired during the conference. It is helpful to our analysis, though. I do not get why that is the email. Again, where he's like, oh, your message omits from the chain my conversation with Chris last night on the topic. And then that's what he puts in. But maybe it's because it also maybe didn't have this part in it. It seems you misheard our conversation. So I don't know, but what we do know, as we'll get to with the judge's orders, is there are still parts of this chain missing. What they filed is not the complete version of the emails. So then she responds. All right, he sends that at 12:48, and on June 24th at 5:40, he responds. Murphy does. Aaron, understood. Period. What is your availability for a 9C call tomorrow? I can be available before 10 a.m. or after 12 p.m. So again, Murphy still wants to confer. Then Murphy sends another one. So that one's at 5:40 p.m. on June 24th. And now we've got June 25th at 1:43. Aaron, following up here, we noticed that Miss Read's 9E notice was e-filed prior to our receipt of the corrected motion. Do you intend to file a corrected 9E to reflect that the second motion was served on June 23rd? If not, can you please provide your availability for a 9C? Again, 9C, C is for confer, for them to talk before she files it. All right. Then she just comes back with another email of hers. All right. June 26th. So the following day at 12:31. This is definitely one that the judge asked for answers to. Aaron, you have ignored my email for 2 days. Regardless, so that the record is clear, we have not agreed to accept, nor do we consent to, any amendment to your June 18th motion. Rule 9A does not afford Ms. Read the opportunity to unilaterally supplement or amend a motion. Indeed, your notice to the court indicates the motion was served on June 18th. Accordingly, we expect to see in the 9A package filed with the court the motion that was served on us on June 18th and referenced in Ms. Read's 9E notice. Guess what? They filed the one from June 23rd. Okay. So should Ms. Read fail to do so, or should you seek to amend your 9A motion after service, we will seek the appropriate relief. Plaintiffs reserves all rights with respect to this issue. They're like, we haven't agreed to shit. We haven't consented to shit. I know we're emailing and we're conferring and we're talking, but we're reserving all our rights to say fuck you and to try to get a default, which never is happening.
Babe, do you think that Kieran's a woman? Because it's a dude.
No, I don't know why I keep doing it.
It's
Kieran
a nice, strong Irish name.
Right. I know which one Kieran is, and I don't know why I keep doing that. Sorry, guys.
But the snark level, like, this is the kind of shit you really see way more in civil litigation between lawyers than you do in criminal. That's not to say that you can't have some kind of like little bit of heated back and forth between a prosecutor and a defense attorney, but it never reaches this level. Like the level of petty that's going on in these emails is exceptional, and it's not that uncommon. You know, it's like, and again, I just want to remind everybody, like, if you're on this is a civil case. It's about money. Karen is free, which is the most important thing here. I get, and again, I understand that they came into this thing with the concept that they wanted to get justice for John O'Keefe, and they still may get some version of that. But really, what civil cases of this nature are about is cash. That's it. So everyone, just always keep in mind when you're starting to feel ooky about what's going on in the civil case, just remember, yeah, money is security, but it ain't your freedom, man. Money comes and goes, and you can appeal and you know, like, there's all kinds of things that, like, getting a judgment in a civil case doesn't mean you're getting the cash. Let's just be straight about that. So Karen's freedom is paramount. That's what matters most. So just keep that in mind when you're getting upset about what's going on in civil litigation. That's one thing that I want to just constantly remind you of. Freedom is paramount. Freedom over money any day of the week. Like, I ask every single exoneree who was wrongfully convicted, who has then got, you know, a substantial amount of money, would you rather have $16 million, or would you prefer to have the 23 years lost back? And every single one of them say, I want my life back. I want my time back, because money is money.
Right.
Freedom is a whole different thing.
Right. So here is the judge's, this is what happens after they file their, I don't know if that I can blow. Oh, okay. I can blow this up. All right. So on July 7th, and we went over this one on like our last live. Okay. So the judge is ordering Karen's lawyers, okay, Seligson, to provide Word document versions of Miss Reed's special motion to dismiss dated June 18th and June 23rd. He wants to see them both. Okay. He also wants to know, he wants an affidavit setting forth if there was any written or oral response to the June 25th, 1:43 p.m. and the June 26th, 12:31 emails from Rosenberg, Seligson, and Waters. If there were, a copy of any written response shall be attached to the affidavit. All right. So then, and that's not something that's going to hit the docket. That's something that was being emailed right to the judge's clerk or whatever they have for that. And then this order comes out yesterday. Okay. This order comes out yesterday. So he says, Karen Read's lawyers provided a response to my June 8th order. The response identifies a June 26th, 12:31 p.m. email from Rosenberg to Attorney Murphy. Attorney Murphy is ordered to email today. So she had to do that yesterday, or he had to do that yesterday. I don't know why I'm doing that. Setting forth the reason such email was not included in the Exhibit B to his declaration of July 7th, 2026. And what I never really quite understood, so I don't know why I can't share this screen instead. So is the Exhibit B, because so what we just read was all the emails that were attached to Exhibit A. So let's see. 12:31. No, here. Hold on. 1:43 and 12:31. So it's a little bit of a pain in my ass, tell you the truth.
You're lucky you're not down in the basement, because I'd be telling you that if you were using 2 screens, it would make your life so much easier.
Right. So these emails are also in the other one. So you've got the June 26, 12/31. Let me just double check because
the judge initially requested the missing email.
right,
If there
so
was one, like, so the original order that we went over a few days ago was kind of putting Karen's lawyers, their feet to the fire, saying, okay, I need affidavits from you guys as to 2 dates with 2 different times. I need to see if emails or conversations over the phone took place, and I need you to write it up in an affidavit. If there was an email sent, I want it attached. What happens after that is Aaron sends the email and an affidavit, and the judge is like, okay, well, now I've seen that they did have a conversation and that there was an email that was sent. Now he's turning back around and going to Murphy. The thing that's strange to me here is that Gildea reads everything. Gildea
clearly,
has to be aware that Karen Read's team screwed up.
well, he is, but he wants to know why one of the lawyers is like excluding part of the conversations, and it seems misleading in some way. There must be,
because right. I mean, he wants all of the conversations that took place, so that when Karen's team comes in asking for leave to file, an amended motion to dismiss, he's got all the intel, and he wants to see if there was an email that went from Read's team to them, and then something back from Murphy wherein Murphy was like, no, however Murphy responds to it in terms of them trying to work this out, or it's not on the court's dime.
Right.
I mean, that's the thing about civil litigation. Again, the judge wants the parties and the lawyers to work shit out as much as humanly possible, instead of coming in front of the court with every single thing that you're bickering about. They're like, the civil judges are like that, and they need to be. Like, figure your shit out. Like, I'm not going to handle every single thing that you guys have that's going on between you, that you can't act like adults and just give each other the professional courtesy to get shit handled. It's tiresome for the judge, and it is.
So this is the email that the judge says, I want to know if you responded, one of them. And this is the email that the judge says that Murphy or Rosenberg, whichever one of them, produced the email chain that showed that they did in fact respond. But here in their Exhibit B, it goes from June 26th at 12:31, and it did in Exhibit A as well, so I don't get the difference. It goes from June 26th at 1:43 to June 26th, with showing like that there was no response in the middle.
25th, it goes back a day. So
right.
That's the 25th, yeah.
Because and so the judge says that there was a response to the June 26th, but it doesn't show there was a response to the June 25th. So, and Murphy didn't include it. Like, why in the hell did he start with June 26th?
No, I want to address this real quick. Otto says, Defense Diaries pod, Murphy was trying to get a default like Alex. Completely different situation.
He's trying.
Alex Jones was a sanction.
Right.
That was a default by sanction. That wasn't a default because of
not,
as Ali likes to say, form over substance type shit. That was a substantive sanction against Alex Jones because he was not complying with discovery at all. And the judge is like, you know what? I'm barring you. Like, you're refusing to turn over shit. You're making things up and sending bullshit. Here's what's going on. I'm barring you from providing any of it. You have no case. Your case is defaulted. Good luck. Take care. It's completely different circumstances. Completely. Remember, guys, we're in the very, very early stages of this case still, believe it or not. With like as much action as there's been, this is the early stages of litigation.
Right. And well, first I want to say hi to some new members. We got, you say her name. Leah Korsheen, Korsheen, and Kelly, and Quiet Things, and Law Nerd. We know Law Nerd must be returning new member. What do all those people get, babe?
Family hugs. That's what y'all get. Welcome. Thank you. We love new members, obviously.
So I think here's what we need to
Kasha gave the love too. She gifted 5 DD podcast memberships. Thank you so much. We appreciate that. And we love all our new members. And I'm sure all the new members that got gifted those thanked Kasha as well. Make sure you do that in chat if you haven't.
Right. So here's the thing. All right. They didn't respond to a lot of the new allegations. And what we are going to do is, go over the new things that aren't in there. Because again, in the first complaint, there was essentially nothing against Karen Read directly. Okay. So as far as anything that she did or said directly against a specific identifiable plaintiff, that was like straight up defamation. Like there just really was absolutely nothing. And the new motion, it says like they don't identify any specific things that Karen said. These are all general. They talk about the House defendants. There's not anyone, like it's referring to what was in that first complaint, but it's like anti-SLAPP. You can't sue me, right, for petitioning the government, so they only covered like these things that when they amend a complaint, it's to fix something that they know is going to be an issue. Like, oh, all right, they got us on these issues here that they raised. And to be fair, Karen's team, parts of their motion are genuinely strong. The statements she made to police, reporting to law enforcement, it's classic petitioning. The statement to her own lawyers, court filings, absolutely privileged. You cannot be sued for what your lawyer argues in a motion, period. That's right. Black letter law in Massachusetts. The emotional distress counts, there's solid attacks on those.
And that extends to all the people out there that were discussing what Karen's lawyers filed in motions, such as every law tuber. When the motion to dismiss in the criminal case came out and they laid out their third-party culprit theory, it became fair game for us to discuss it because they put out a non-frivolous theory of what may have happened that night. And it was fair game for everybody to talk about, so it's like when all the antis are like, oh, I'm so happy that you're calling them this and calling them that and talking about tough shit. That's not the way this thing works. We get to talk about all of it because you know what? That's just as likely as what the state's theory is. It's like the concept of us only being able to talk about what the government's theory in a case is absurd. Think of it that way. Because when the state comes in a criminal case and they put their theory of the case out there, it's all it is. It's a theory. It's nothing more.
Right. And you can't just take a defamation claim like she said bad things about me and convert it into an infliction of emotional distress. If it's constitutionally protected activity, it's constitutionally protected activity. So go F yourself. You can't call it infliction of emotional or distress and walk away from it. But these things were not typos. They were not little mistakes. They literally, the entire motion was drafted against the April complaint. You can see it in the count numbers, but not only that, in the content. Like I said, it's saying words that aren't true anymore because the new complaint does something different. But oh wait, sorry, I was going to try to pull up this the footnote here. So, but here's where things get better than what everybody might think. Again, the amended complaint was filed June 5th. And there's an argument, and I posted about this last night, that the amended complaint restarts the 60-day clock, at least for what the amendment adds. So there's this case, it's Bristol Asphalt, and it's a 2024 Supreme Judicial Court case that rebuilt the whole anti-SLAPP framework. There's a footnote where the court measured the 60-day window from the amended complaint. Now, that's a footnote. It's not a holding. So I want to be precise, but that is, there's a lot of weight that you can at least argue that they said that it can be based on the amended complaint, because the rule itself says from the date of service of the complaint, like from service of the complaint. So that's when the 60-day clock really runs. But there is this law, this argument within this footnote that does say when you have new allegations of new activity, that you can argue that it should restart the 60-day clock. And babe, as far as substantive rulings, what's your position on if the court, like if this goes to an appeal and they were to request a time to amend it to address the new claims, and he was like, "No, I got a hearing scheduled. Go F yourselves."
The appellate court's kicking it back and saying, "No, here are the merits." You got it's best practice for any judge in a case like this, or in any case, to get to the merits of it, get to the actual arguments as to whether or not the thing should be dismissed pursuant to the anti-SLAPP statute, because that's the entire point of the statute, is to avoid needless litigation. If you can answer the question on the front end as to whether or not this is actual defamation that needs to be litigated and what the penalty or the judgment should be, if it is the ultimate question here. And if you don't need to get there because you can look at it and based on the law, it's not defamation per se, then the appellate court's going to want that to be dealt with. Like, because this is a technicality thing. Like, I always get super pissed off when I hear people talking about motions to dismiss and, evidence was thrown out and the guy got off on a technicality. No, that's the Constitution. This is literally form over substance. It's Allison's favorite phrase. That's exactly what this is, meaning they're just relying on statutory language and a technicality in the law in order to try to make this thing go away. Because say, for instance, like, and what do you think about this, babe? Like, if they went on anti-SLAPP, they're not going to be able to amend. Like, I don't see a way for them to be able, because if like typically, if you get your like a 12B6, which is failure to state a claim, meaning that under the laws that exist, you have failed to state a claim, and we're bouncing it on that. You have the opportunity as the plaintiff to come back and refile an amended complaint, curing the ills that existed in your complaint. Here, babe, what do you think? Like, if you're losing on anti-SLAPP, I don't see that there's any way to cure that. Like, in terms of saying, okay, well, we're going to come back and we're going to refile a defamation claim. And we're going to kind of get into this briefly because Allison schooled me on this last night. She's like, look, an IIED, which is the intentional infliction of emotional distress, and NIED, which is the negligent infliction of emotional distress, those claims can't be used as a backdoor to sue them if your defamation claim fails. So
basically the same thing. You'd have to take all those parts out of it and see if it still constitutes, emotional.
So that's my question to you in light of, and I know I'm asking you a question you may not have researched yet, but if this is dismissed, let's say that they go ahead and they're allowed to amend their motion to dismiss. All right. And then the judge gets to stage 2. It's like, yep, like I find this all to be petitioning activity. Sorry, your defamation claim's going away. Do you think, or do you know whether or not they would be able to amend? Or is it like you have to assume that they put in everything that exists?
Right.
So
I don't
like,
know. I would think
could
they might
amend?
be able to amend, but I honestly don't know the answer. But so let's just now, because you brought that up, we're going to take a step to the side right here, and we're going to look at the amended complaint and the allegations in just the things that are new in the amended complaint that they did not respond to. Okay? Because that's really where the shit was, because they had nothing. And I wonder if because typically you would expect an amended complaint to come after the defense has kind of said, here's where you fucked up. And I wonder if they went based off of like law tubers or other people being like, everyone's saying they didn't say anything about Karen. What did Karen actually say? You know, and Aidan's is all petitioning activity. And Karen's is, you know, like nothing. So here is the amended complaint as far as just what's most relevant here, and it's not all that much. So hopefully you guys are down for this. So during her first criminal trial in 2024, Read had a documentary filmmaker, Terry Dunn Muir, record her preparation for trial, including interviews with Read, her attorneys, her family, and recordings of conversations between and among Read and her counsel. During these interviews, Read personally and her counsel on her behalf defamed the plaintiff. They're claiming on April 25th, Jackson's verified to Muir, and I don't care. Right there, you just rip it up and throw it away, what Jackson did. Jackson saying words is not Karen saying words. And her production assistants, the statements Read gave to police when she was arrested. She gave them to the police, period. That Brian Albert, Colin Albert beat up John, my taillight was cracked, and John was pulverized. Read was present during Jackson's recorded statement and did not deny that she said those things. She did say those things. So that one doesn't really matter. On or about April 23rd, 2024. So this is after the complaint. So that could be what was the impetus of the amended complaint. Read gave a series of personal interviews. So she falsely stated Jen McCabe got herself into a bad mess that night, and she helped clean it up. I don't think I'm just going to do this. So I don't think that Jen laid a finger on John. I don't think Jen laid a finger on John, but Jen knew John was dying and she helped expedite it. So she's a first-degree murderer and she knows it, but it was probably accidental when he became severely injured, and they, referring to the other plaintiffs, just finished him off by putting him out and leaving him in the snow to die.
Yeah, see, and just for the record, and it's nitpicking, like that's not first-degree murder. Like, you know, like what she's describing is at best second-degree murder. But, you know, that's nitpicking.
Well, I guess it depends on which statute, but sure.
During that, I mean, their statute, there's no way.
He's alive. She puts him out in the snow to die. That's
well, you know, like, you have to know that he's gonna, like, what happens if they put him out thinking he's gonna, you know, like we didn't kill the guy. Like he's gonna get up and walk away. You know what I mean? That's
then maybe it would be some other degree that they just watched from the window.
I mean, if I was defending,
went to bed, I don't know. But anyway, let's not get sidetracked. But the words that she spoke is what they're saying is defamation. So that's actually words she spoke, identified to a person, and they don't address it. They don't mention it. So there's no way that they can say that they like intentionally just left this one out. So during that same interview, Read falsely stated, referring to, among others, the plaintiffs, they are being federally investigated and they know it. They know they killed John. During that same interview, Read was asked what she thought about Kearney's tactics that had resulted in criminal charges against him for witness intimidation. Read responded in part by referring to the plaintiffs and falsely stating, "It's impossible for me to have sympathy for any of these witnesses. They're murderers and they know it." On June 15th, she gave a recorded statement, and she said, "What I think happened," what I think may have happened if the Higgins motive is the motive for what happened to John, or if it's combined Higgins and Colin Albert, who I think is the biggest hothead of the whole group. I think Higgins could have shared with Brian Albert what happened between Higgins and me, and Brian Albert used that as another reason not to like John O'Keefe. So Brian Albert has his friend, Brian Higgins, and his beloved nephew, Colin Albert, coming to him saying, John O'Keefe is a pain in my ass. There's enough motive to go around. I know that Brian Albert did not care for John on his own. I know that Colin Albert had issues that I witnessed with John. So it could have been as simple as everyone was drunk and John got mouthy with Colin and, caught an uppercut, and it just escalated from there. On June 24th, Read made a statement. I know Brian Higgins had a role in helping kill him, help him get him in the snow, and help frame me. But I don't think Higgins necessarily would have wanted to really hurt John. I think Brian Albert and Colin Albert would have enjoyed roughing John up.
That's what I was talking about. But hold on, babe. So if you're just joining us and you're not sure what we're talking about, like essentially what we're talking about, the motion to dismiss that was filed in the defamation lawsuit against Karen Read and Aidan Kearney. There's been a motion to dismiss that was filed. That motion to dismiss was based on the original complaint. There was an amended complaint. What we're going through right now is the language that was not responded to in the motion to dismiss that comes from the amended complaint. So this is where the problem lies for the defense, for Karen Read's team right now.
They didn't attack
allegations. Like all of this is not addressed in the motion to dismiss. That this is where the problem lives right here.
Right. And again, it specifically says they didn't include anything like this because in the first complaint they didn't. So, all right. So 98 says that Karen said, "You make such strong statements about, I think Colin Albert killed him. I don't know how without getting sued, because I don't even know if I hope we're going to be able to use some of that because it's public record what you said." And Read responded, "Oh, sorry. Okay." So the documentarian asked Read that, and Read responded, "If Colin can prove that I'm lying and this is defamatory, he can sue me." All right. And then you've got this paragraph 105. Read admitted that her lawyers said they could provide information to Kearney so long as it was public, but advised her not to speak with him directly. Nonetheless, she said she got nervous about who she was using as a third party, so she ended up developing a direct relationship with Kearney herself. They, quote, started talking about the case probably once a day, 5 days a week. Read, however, failed to disclose to HBO that her attorneys on her behalf were directly communicating with Kearney at the onset of the defamation.
Yeah, guess what? So what?
Right.
Karen Read can talk to whoever the hell she wants to. Period. Right. End of conversation.
Too bad, too sad.
Yeah, it's like that concept that the anti side keeps trying to cast shade, that it's forbidden for a defendant to talk to whoever the hell they want, is insane. That's not the, if you've been charged with a crime in this country, you're still allowed to talk to people. Now, if you're in custody, don't be an idiot because they're recording everything on a recorded line from the jail. So, we always tell our clients, hey, don't be a moron. They're listening to everything that you're saying. So, just be careful with that.
by the way, this falls under in their complaint, the conspiracy continues. So I don't know. Oh, this is the factual background. So they must have incorporated it. All right. Sorry, guys. Close your eyes. Close your eyes.
Allie's not trying to induce any kind of seizures right now.
And I think there's only a couple more that I highlighted. Let's see. What's coming up? This is under Defendants. Defamation campaign continues after the trial concludes.
Yeah. Sub Rosa, she says, hello, is it defamation if it was never published?
It's published to the people that in that room.
Right.
Said
like
it.
People have a misunderstanding. And I know that like somebody tweeted at me that Aidan was saying that things weren't published. He doesn't have a very clear understanding of what the legal definition of publishing is. If you say something to another person that's defamatory, technically under the law, that's publishing. Just so you know, like it doesn't have to be on a TV show. It doesn't have to be on a documentary. It doesn't have to be printed in a magazine. Yeah, it's like that. That's why, like listen to the lawyers as far as the technical side of the law, so that you have because people get confused if they're getting bad intel. And I mean, Aidan wasn't doing that intentionally. Aidan's just not a lawyer. So he probably, because I think most people would think, well, publishing, this wasn't out to the public. So how could that be published? That's not how defamation law works.
Because in these things, the camera crew was present.
Yes, Nikki Crayon's libel is printed defamation. Slander, spoken.
Yes, just remember S, spoken.
Yes.
Sorry.
Oh, she gone.
Nope, sorry. I had to plug in my.
I was just kidding. We could still see you, babe.
Oh. All right.
Welcome. Family hug to Brian's deviated septum.
So you've got this one, and there might be more, but I'm just giving you the highlights here. And we are going to address this more fully once we get their response, the response filed by Karen's team, which is due today. So then they're talking about Aidan hosting a live.
Their response better be an amended motion to dismiss without asking leave. I'd rather just do it and ask for forgiveness later.
You just file the motion with it,
right.
File both. Exactly. But you could also apply, see, a lot of their arguments will apply to those statements as well. So at the end of the day, the judge might even let it go through if their response does raise it. The reply raises it. Now, here's the thing that they get wrong. In the let me take this down and then I'll come back to it. So one of the things that they argued, in they being the Shoulda-Been-Suspects lawyers, is that Karen Read cannot raise new issues in her reply brief. And they cite a case for that. That is appellate law. In an appeal court, I file my issues on appeal. I put them all out. I got to say them all my issues on appeal. Okay. Then they respond. In my reply, I can't raise anything new that I didn't already have. That is not a rule for what happens in a trial court. And the trial court has discretion, and they want things to be heard on the merits. So they could very well say, Your Honor, we cited this case and it applies to this for that reason. We cited this, but the affidavit doesn't address those. I mean, there's some other issues, like they would need a new affidavit from Karen that addressed those things. But I think that they can do it. I would absolutely be doing it in my reply. And I would absolutely be arguing that my response to the First Amendment to the original complaint on all the claims unchanged needed to be filed by the 18th. I have 60 days under the statute to respond to the stuff in the amended complaint. And, you know, I'm doing it now, and I would do it.
What
right there.
Allie's doing right now is describing to you guys the workaround. This is what should be done. They're within, but babe, let me ask you. So as you aptly noted, it goes by whenever notice was provided, right? So whenever they served it upon the other party, that's actually when the clock starts, as opposed to
the complaint and the amended complaint.
Yeah.
Yeah.
All right.
Yeah.
So like what date was that? Do we know?
It was like April 20. Let me see. I have it right here in front of me. So
I'm talking about the amended.
June 5th.
Okay. So June 5th.
Got plenty of time.
Plenty of time.
Right.
You got like almost.
The problem is there was a deadline that they had to file, but that deadline was also done before June 5th when they filed their amended complaint.
Right. And that was like a judge imposed deadline. That wasn't a statutory deadline.
Well,
right?
the 30 days, let me just find the original complaint. I'm just going to reopen it because House Suspects original complaint. The original complaint was filed April 16th, May, June. So the judge gave him like 2 extra days from the 60 days, but that's fine. That was it's 60 days, but the rule specifically says the judge has discretion to extend it. So, and he did here. He made it the 18th, you know.
Oh, this is interesting, babe. Kyle said, "Hey, Bob, do you think that the 4-ish hours will be enough to get the hearing done on the 14th? It is at 10 a.m. and the federal judge has denied Karen's motion to continue. So it will be at 3 p.m. the same day."
That's what I'm saying. That was what I was saying earlier, that because they've got Aidan's motion and they can still argue everything going to the original complaint, with that limited time, they're probably going to need another day anyway. So I can't imagine in a million years why the judge wouldn't allow them leave to respond to these issues, give them extra time to respond, you know, a back and forth just on the new stuff. And, you know,
I mean, this is a no-brainer that the judge is going to grant them leave to.
If they ask for it, but they haven't asked for it. Right now, all they've done is say, we didn't make a mistake. We did what we wanted to do. Well, and
that's them privately dickering with the other lawyers. Right. Like they're going to have to do the right thing for their client because that's what their ethical duty is. Right. They've made a mistake. Big deal. We can cure it. Okay, and we're asking Your Honor to cure it. The judge is going to say, yes, go ahead and cure it for all the reasons that we've been talking about. Right. Judges aren't trying to get rid of cases like this because they know it'll get kicked up in appeal, which is the question Allie asked me earlier. If it gets kicked up, what is the appellate court going to do? They're going to say, you know what? Deal with this. Like, you're being lazy. Just let them do what they need to do and deal with it on the merits, period. End of conversation. So that needs to take place today.
Bob and I do not think it's dead. We just think that the defense, that Karen's lawyers need to do something.
Yes, they have to do something. Right. They have to do something.
Foxy says bound to happen about too many lawyers. So too many lawyers cases at once. And then
too many chefs in the kitchen.
Right. And then Optopoppet says not a lawyer, but this feels like we're approaching malpractice territory here. Abso-fucking-lutely if they don't.
Abso-fucking-lutely. Like if they don't do what we're saying they need to do.
Right.
You are definitely in malpractice world.
But not if nothing happens. If the judge gives them time, and the judge should.
They cured it. Right.
The judge absolutely should. The case law is very, very clear. The judges on something as significant and as the anti-SLAPP, and all the law says that they prefer it be heard on the substance. Yep. And especially here where it's within the time of the statute, as far as I'm concerned, I don't think the judge has much of a choice. Okay. I think he's got to give them the time, but Karen Read's team either has to say in their response, we're considering this as only a response to the allegations in the amended complaint that were contained in the original complaint. And we are going to seek leave to, you know, file a motion attacking the new stuff within that 60-day period, whatever, or they have to do it now. They've got to do something. And it shouldn't be approaching malpractice territory because the judge should allow all this to happen. But if he didn't and the appellate court denied it, that's sure as shit malpractice, as far as I see it.
Oh, yeah.
But I don't think it can be. The statute says 60 days. It doesn't say the judge can make it less. But the question is this amended complaint going to count as something new enough to stop that clock, from running? Because it's that issue is not something that's like black and white set in the law. It's like this footnote,
Yeah.
And then Cat Lady says, do Matai at all realize they have a crap case and are trying to find a technicality to win? Abso-fucking-lutely. Abso-fucking-lutely. They do have a crap case, and they're looking for any and every possible way to get this dismissed before it gets, ruled on the merits. And Bob and I both think that this new activity is petitioning activity, but not on the basis. I don't know about the basis that they have alleged right now, because again, their basis was based on the way the complaint was written originally. So they're like, she's defending herself in a criminal action. She's asserting her innocence. She's hoping that they dismiss the case or don't try the case. And she's trying to get the wrongful, O'Keefe's to realize they've sued the wrong person. I am not sure relying on a civil case helps you with petitioning activity. I would be trying all sorts of other things, such as trying to get the public outrage to put pressure on the prosecutor's office, the police department, and or the feds to reopen, expand, or expedite their investigation into any liability, any culpability on the Shoulda-Been-House-Suspects, any public official misconduct as far as covering it up to make it look like it was Karen Read. So, I would expand it a little more. And then you've got the retrial pending. So to try and apply pressure to the prosecutor to not retry it, or to reduce some of the charges, or to whatever. Because look, they have to get around how speaking to a producer and going on a public commercial documentary is petitioning activity. And if it's the activity includes getting the activity reasonably directed at getting the public to, ask for this change from the government. And right. I do think you can get to that, because public outrage has a direct impact on pressure to them to expand their if it's not her charges directly, it's also to expand, reopen, or expedite any investigation, federal or state, period. So there's some more things that,
and I think a perfect example of what you're saying we saw in the Aaron Spencer case. There was a lot of public outcry about that case. We covered it heavily. We were definitely doing petitioning activity on our channel. We did a 12-hour fundraiser, had a bunch of lawyers on. That's petitioning activity, because we want the government, by hook or crook, whatever method it is, to hear the people and what the people's will is in terms of what they think the government should be doing in that case. And you know what? The judge heard it and the judge dismissed the case, because that was within the judge's purview in that particular matter. So, what constitutes petitioning activity is a really, really interesting conversation. Allie and I in bed last night had a very interesting conversation about the 50-car rally, that happened. And we had a bit of a debate about whether or not that constituted petitioning activity
or harassment,
or it was harassment, and it was a really, really interesting conversation. So what kind of is qualified as petitioning activity is a pretty fun intellectual conversation to have, because you can really stretch it,
especially Aidan. I mean, Karen can to a certain regard, but thinking about it, because the rally was Aidan, is like, yeah, he's going there and yelling at them. That's not asking the government to do something. But you know what it is? It's getting the people involved and getting the people upset so that they can then demand their officials take action or do something or explain something or investigate something. And he was always asking for that. He wasn't just screaming at them, "You're murderers." In the background, it was always, somebody needs to look into this. Somebody needs to investigate. So it was to bring awareness to that. I think those arguments carry water with what he was doing. And I think that they carry water with Karen going on a nationally publicized thing, even though she wasn't saying in that, so public go out and be outraged and ask for change. I still think that it
100%. And to bolster your argument, Karen was pretty clear on that documentary, and I can't remember if it was the HBO one. She's like, look, the likelihood is I'm not going to be able to testify, or I'm not going to testify during the trial. I consider this to be my testimony. And that was her basically telling the government, fix your shit. And the government is law enforcement, the prosecutor's office, the judge. Those are all government. Like, just so you're clear on what constitutes the government, all of those particular agencies and individuals fall under the government. They're paid by the government.
She can't argue that she expected the judge to do anything.
No, like, I'm not even talking about the judge. I'm talking about the prosecutor. She could argue that she was expecting the prosecutor to watch it.
Right.
You know, I mean, because at the end of the day, it's Morrissey's the one who's making the decision whether or not to proceed on the world's most expensive DUI or not.
Right. Also to rally the public behind her and demand of their the locals, at least, to demand of their public officials to stop prosecuting her, don't retry her, lower the things, start an investigation into these other people, look into public corruption, and you know, so
because that's another thing. Like, you know, when you hear the word petition, your brain goes to a very specific thing. You're thinking about a document that somebody's knocking on your door and somebody's saying, hey, we have a petition here. We want you to sign. I'm trying to get on a ballot. I'm running for office. I need X amount of signatures. Or we're trying to get this referendum on the ballot. Would you sign this? Like, so, but petitioning activity is much bigger than that. Like picketing outside, you know, when you make up a sign and you go out and you stick it on a stick and you're screaming and yelling, the point is that you want the government to hear what you're saying. That's and right. It's no different if you don't have that sign and the thing that you wrote on it and doing that, if you're just saying it out loud where the masses can hear it. It's the same exact concept.
Yes, yes. And Music to My Soul says, excuse me, Allie, but do you know you're always supposed to shout petitioning activity? I couldn't resist. I love it so much. Don't worry. We're going to get to it when we're reading Aidan's complaint,
because there's all kinds of petitioning.
Yeah, right. There. And we just wanted to go through this and say, yes, there was a fuck up. Yes, it is big, but is it a death knell? Not in our estimation. It shouldn't be. No. And if it is, I would hope, all I can say is hope.
It's going to be an interlocutory appeal.
It's definitely going to be an appeal. Right.
So like interlocutory appeal means it's happening while the case is active, as opposed to after there's been final judgment. So if Karen, if her lawyers do the right thing, which I'm assuming that they will, I would be stunned if we don't see something today when they're filing what they're required to file today, that's doing exactly what we're saying that they need to be doing. Like again, they made a boo-boo.
Right.
It's a curable boo-boo. And I will fall off my ball here if they don't file something that's exactly what Allison's saying should be. Look, I'm filing the notice for leave and then I'm attaching the motion.
Right. And just and addressing the new stuff in their response anyway, you know.
Exactly.
What they can't do is say, no, we responded to what we wanted to respond to. That's what we meant to do. They can't keep doing that. And I understand what you're saying, babe. That's them. What's the word in an email to them? Like when you take not grandstanding, but like whatever in the emails between counsel where they're just, you know, hedging their bets, or
Yeah, well, yeah, I mean,
I can't think of the word I'm trying to think of, but
yeah, I don't know what word you're trying to think of either, but I know what you mean. Obviously.
posturing, right?
Posturing. There,
right.
Was somebody in chat?
No, it was they made of, but that was I'm looking at the supers, so I don't know.
Wow,
we also have another new member, Dreamboat Annie. What does she get and all our other ones? I can't remember if you gave them all family hugs.
Aw, family hug.
And Dr. Jen Toxic says, Allie, you look stunning today. Thank you.
Agreed. I mean, you guys have heard of the word dickering, right? That's a real word.
Bickering?
Dickering.
That's a real word?
What?
Dickering?
Oh, babe. I never use fake words unless it's kerfuckle or disadulation. Yeah, dickering is 100% a word. And that's exactly what they're doing. Like in the terms of like.
Wait, give us the definition of dickering, please. The official one.
So the official one is negotiating terms. It falls under that. It can be described as going back and forth over the details of a contract or an agreement. Like
dickering?
Dickering. What?
I did not know this.
Girl.
My man is the word.
Hey, listen, if you pay attention, you'll learn something new every day.
Stop dickering.
Yeah, dickering. Real word. It's fun to say, too. Go ahead, everybody. Say the word dickering.
Paula MC, thanks for your continued support, says, do you think Gildea should recuse himself? I don't know. I need to see a little bit more. I do think, and I've said this before, that I think that that what he did in the last two hearings where he made assumptions about the strategic nature of the timing of the depositions, and then the listening where he just assumed that the defense did something wrong. I mean, yeah, well, it is the defense here that Karen Read's team did something wrong and leaked something, or you know, that they do show some sort of bias in his own mind. And I haven't given enough thought recently to see if he needs to recuse himself, but I see issues for sure. But I don't think he's going to actually recuse himself. There's not a motion, before him.
I mean, look, I took a step back. Like as soon as I saw his email or his order to Murphy, like I think he's got a certain feeling about the Read team, just again, and I think that's based on bullshit. I think it's based on, him not wanting what happened in the criminal case in terms of all the outside noise happening. And he came in, chest puffed out, like, oh, I'm not going to, like, this shit's not happening on my watch. I'm going to knock that shit down immediately. And, at the same time, when he fires at Murphy, like, all right, well, you know what? He provided what I asked. Why are you skipping shit? And the things that you're presenting to the court. So, I mean, he called Murphy out on his shit. So, I mean, like, being a civil judge is tough. Like, cause you're listening to dickering all the time. It's like a constant thing that you're dealing with, not just in Karen's case, on every case in his call. Like, civil discovery is a nightmare. Like, if you were to dig into any of the huge cases, like big tobacco, any of the big pharma cases where you've got plaintiffs trying to dig to find out, there was a guy who worked in the lab who said, yeah, this shit's going to kill people. But you know what? We'd be better off a few people dying and paying out a few lawsuits than recapitulating everything that we've done. Yeah, it's like you're looking for that kind of smoking gun evidence in those suits, and they don't want to turn it over. And when they do, if they're forced to do it, they're gonna send you the needle in the haystack shit. They're gonna send you, a box truck filled with thousands of bankers' boxes filled with documents. That's old timey, but now they're going to send you a 50 terabyte flash drive that you've got to try to dig through, so it's like, that's always how it is in civil cases. Both sides fighting about what they're going to have to turn over for various reasons, and the judge acting as a referee.
All right. So before we move on to read Aidan's motion, do you want to cover Karen's affidavit, that supported the motion or save it till later. But also we've got an affidavit of Colin Albert back from the the defamation case. I'm not confusing myself here. If you're talking, you're muted.
I'm not. I didn't say anything.
Oh, didn't answer my question.
Oh, I'm sorry. I was reading the chat.
Should we read Colin Albert's affidavit before
let's
moving?
leave it to the chat. So do you guys want to hear Colin's? I'm sure you guys have heard it because I'm sure it's been covered ad nauseum. Or do you want us to get right to Aidan's motion to dismiss, which is, lengthy. It's got 30, I think it's 34 pages, something like that. And we're going to read it. We're going through history. We got one Colin.
One Aidan.
We got two Aidans. We got three Aidans.
We got another.
We got
Colin.
Chloe's mom saying yes.
All right, Collins is short. I'm gonna put it up.
All right, just fire.
I've decided.
Executive decision made.
Hold on. Oh, there might have been. Let me see. Oh, that's the original complaint. Colin Albert. It's kind of hard to see. Is it up there?
I can't. It's super shitty. It's got some giant. Yeah.
Up. Okay. So I'll read it. I, Colin Albert, on oath hereby depose. I am not a party to this lawsuit. Everything I say in this affidavit is based on my own personal knowledge. On the evening of January 28, 2022, I went to my aunt and uncle's house at 34 Fairview Road in Canton, Massachusetts. I was there to celebrate my cousin Brian Alberts Jr.'s birthday. I arrived at 34 Fairview at about 10 p.m. At about 11:55 on January 28, 2022, I texted my cousin Allie McCabe to see if she could pick me up from 34 Fairview. She texted back that she could, but had to drop off other people first. At around 12:10 a.m. on January 29, 2022, Allie McCabe picked me up from 34 Fairview. Allie dropped me off at home about 5 to 10 minutes after picking me up from 34 Fairview. I stayed home for the rest of the night. I testified before a federal grand jury regarding the investigation into the death of John O'Keefe. I also testified at the first two criminal trials against Karen Read. On April 21st, 2026, I was served with a subpoena from Karen Read. The subpoena told me to turn over certain documents by April 27th and to show up for a deposition on April 29th. I was ready.
I'm sorry to interrupt you. What case is this filed in?
Defamation.
Because people are asking. Okay.
Defamation.
Yeah, I mean, this has been out for a hot minute. Like, this is not breaking news here. So,
right. No, this just got filed.
What? When? Today? A couple days ago?
This is the 8th, but it just hit the docket.
Oh shit! All right.
Yeah.
Is it the same in substance as the first one?
What? What first one?
I think there was another affidavit. I thought.
Well, if there was, then I don't know about it.
It says this is the affidavit that was relative to mention. Joe is saying this is the affidavit that was filed with the previous motion from the wrongful death, not the defamation. Yeah,
right, well, now
that's the wrongful death case.
The one that ends in 4-1?
Well, I'm just looking at it. It's got the O'Keefe family in it. The O'Keefe isn't a party to the defamation.
Oh, then why did they file this in? Okay, wait. 9-2.
Are you saying you found this in the defamation docket?
This is on the defamation docket.
Yeah, I mean, they did scratch out the case number there.
Yeah, the defamation case number is the one that ends in 541.
Well, where are you seeing that on that particular document?
Well, I'm looking at it. I'm looking at the docket right now. Maybe it's an exhibit. But it's affidavit of Colin Albert.
Does it have an exhibit sticker on it somewhere, anywhere?
Hold on. So 692 is the wrongful death case.
Right.
And 541.
So here, just show everybody what the filing date is right there. It's July 8th.
So if they've all heard it, they've all heard it. So, I mean, it's short and I'm almost done. I don't know why. You're right. It's on the caption for the wrongful death action.
I thought it was like a Rorschach test there with that weird thing going on there.
I know.
Is that Chloe's head?
I'll just get to the point of what I wanted to talk about this. So the lawyers told him that the deposition was canceled. He told them he was going to have to leave for work. But as for the documents that Karen Read subpoenaed and asked for shortly after I got my subpoena, my lawyers asked me to try and find certain communication that I might have. So yeah, all of this is relevant to the wrongful death, but I don't know why it's filed here. So first, I checked whether I have ever had any communication on my phone with the people listed in the subpoena. I confirm that I have never had the phone numbers of Michael Proctor, John O'Keefe, or Yuri Buchanan on my phone. So I don't have any communications with any of them about anything. Next, for the people whose phone numbers I do have, I checked to see if I had any text with them around January 28th, 2022 about John O'Keefe's death or the investigation into his death. Again, we talked about this before. That was so narrow. To do this, I scrolled back through each text thread I have with those people to January 28th, 2022, and I looked through them for whatever conversations. I also searched using the keywords Karen Read, John O'Keefe, Michael Proctor, O'Keefe, Proctor, and investigation. What I don't see here is pick me up. Hey, Allie, I need to get picked up. I'm still here. I mean, that's my problem with all of this. So that's everything. And so after doing all of this, with one exception, I did not find any communications with anyone listed in the subpoena about John O'Keefe's death or the investigation into his death. The one exception is the text with my cousin, Allie. Again, that she picked him up. Then he said he got a new phone, but he transferred all his data, so he should be good. All right, so let's move over to Aidan then.
Oh yeah, let's go.
All right, I feel like you should put this up on your screen and you should be reading for a minute because I gotta run downstairs real quick. What happened? He says, let's go, and then I don't hear him.
Yeah, I'm all about that.
Okay.
All right.
So I'll remove mine. And I'll see if there's any other supers that we should touch on.
Okay. Let me pull it up.
D. Guidici said, I sat on a ball for 30 years working at the EPA. Oh, at the EPA.
Wow.
And everybody thought I was crazy. It was great. Wildcat says, and thanks for your support. Can Aidan get a fair shake since it was his tweet? I don't know. I see what you're saying. Why you guys are saying, should this guy recuse himself? And is he going to be able to get a fair trial with him?
I mean, I hate that he's on both cases. It's not a good look. It's not a good look.
Yeah. So I think Thornton PD is right. I think they repurposed it. I think they refiled his Colin's because Colin is a party in the defamation case. I don't know for what purpose they repurposed it. I don't know if it's an exhibit that I didn't realize or what, but so wait.
All right. Wait.
No.
That's the wrong. Oh, that's the Oppo.
Right.
That's the Oppo. Sorry. Hold on.
It's listed memo because there is a separate motion. We're not reading that.
Yeah, I had it
incorporated in the memo.
I had both of them up. So just bear with me here for a second. Okay. See, even with two screens, it's challenging, baby. It's challenging. All right.
See, for me, because you're not in doesn't look like you're in Acrobat. Like for me,
I am an Acrobat. I'm definitely an Acrobat. Okay. Let me see.
No.
Okay. All right, I got it. Okay. All right, I'm gonna pull it up in a second. It's a lengthy one. It's a lengthy, but there's pictures. So it'll be fine. All right.
All right, I'll keep seeing if there's any more comments.
Yeah. Here, I got it.
The Goodmans said, and member for 13 months. Thanks for your continued support. Happy Friday to the lovely Matas, and happy Friday to you. Also, Sarah B. Creative, member for 9 months. Much love to you both.
All righty. Okay, so this is the so this is the way they do it in Mass. It's the memorandum of law in support of his special motion to dismiss.
And the motion just basically says this in like a couple of sentences and then says, see the memorandum. So we're just going to read the memorandum.
Exactly. That's where all the tasty tidbits are. All right, you guys ready? Let's go. I'm not going to be looking at chat, so don't yell at me. You guys have a real tendency to yell at me when I'm not looking at chat. All right, so introduction. 3 years ago, defendant Aidan Kearney, an independent journalist and online content creator, began writing articles, publishing videos, and leading protest activity over the prosecution of Karen Read for murder. Convinced that Read had been framed for killing her boyfriend, Boston police officer John O'Keefe, Kearney enlisted the members of the public to demand that the charges be dismissed, that responsible law enforcement officials be held accountable, and that the Commonwealth instead charge plaintiffs Brian Albert, Jennifer McCabe, Colin Albert, and Brian Higgins with crimes relating to O'Keefe's death. Kearney's brash mix of activism, advocacy, and investigative reporting brought national attention to this little-noticed case, leading to the remarkable, quote, Free Karen Read movement. So with Kearney's encouragement, hundreds participated in daily courthouse protests, engaged in public advocacy, and advocated for reform. And that comes from the amended complaint. Kearney's relentless activism, quote, made it impossible for people not to know about the case. Plaintiffs have now sued Kearney for his speech and activism around the O'Keefe killing and the Karen Read case. The legislature, however, has enacted a very broad protection for petitioning activities like Kearney's, and that comes from Duracraft Corp. And that the anti-SLAPP law, which is GLC 231, Section 59H, grants civil immunity for the exercise of the right to petition the government. Its protections extend not only to statements made directly to government bodies, but those made, quote, in connection with ongoing judicial proceedings and statements, quote, reasonably likely to enlist public participation. I'm going to read that again for all those in the back. With ongoing judicial proceedings and statements, quote, reasonably likely to enlist public participation. It's almost as if that's defining exactly what Aidan was doing. So to affect governmental consideration. So Section 59H, the statute, quote, immunizes this broad category of conduct from suit, except where it is, quote, devoid of any reasonable factual support or any arguable basis in the law. Let's read that again. That's where this thing lives. Okay. The statute immunizes this broad category of conduct from suit, except where it is devoid of any reasonable factual support or any arguable basis in the law. And that comes from the case that Allie was talking about a little earlier, which is Bristol Asphalt. All right. So look, the bottom line here is as soon as Bev, and I don't care how she was allowing it in, and she was allowing the third-party culprit stuff to come in through Bowden in trial one. And she said, if you can prove it up to me enough, I'm going to let it come in. Now, it turned out the defense didn't even have to do that because Lally elected to do his pre-Buttle case, if you'll remember, where he was calling them all in terms of the Shoulda-Been-House-Suspects, all like to get in front of the defense doing it in their case in chief. So to me, that ends the argument right there. I mean, clearly it wasn't frivolous. And clearly the judge thought that there was enough there, that there was a reasonable factual support for that to move forward in a criminal trial. All right. So as explained below, the anti-SLAPP law requires dismissal of all of the plaintiff's claims against Kearney because they are based solely on his, she's gone, petitioning activity. I don't do it as good as Allie. And plaintiffs cannot prove by a preponderance of the evidence that his petitioning was, quote, devoid of any reasonable factual support or arguable basis in the law. So here's the factual background. The following facts are drawn from the allegations in the plaintiff's amended complaint and the affidavits and exhibits filed herewith, footnote 1. So exhibits, or each of the exhibits referred to in this motion, exhibit, and he gives an example, is attached to the affidavit of Jeffrey J. Pyle. So Pyle, not Betterow, is the one who prepared this. Okay, so we've got, unlike a motion to dismiss for a failure to state a claim under Mass Rule Civil Procedure 12b-6, a court faced with an anti-SLAPP motion, quote, shall consider supporting and opposing affidavits stating the facts upon which the liability or defense is based. A, Aidan Kearney's investigative reporting and video streaming content. So Kearney is a writer, investigative reporter, and video content producer known as Turtleboy. For the last 13 years, he has published a widely read website currently titled TB Daily News. He also publishes live stream video content. Some of Kearney's best known work has involved police misconduct. In October of 2017, for example, Kearney was the first to report that the state police officials had ordered a state trooper to omit incriminating information about the daughter of a district court judge from an official arrest report. So Exhibit 1, Phil Deemers, Worcester DA's office, state police communicated about scrubbed arrest report of judge's daughter, Allie Bybod. I'm not sure if I butchered that. Probably. All right. Noting that Kearney's blog, then called Turtleboy Sports, was, quote, the blog that broke the story of the altered report. Kearney his reporting resulted in the resignations of State Police Colonel Richard McKeon and Deputy Superintendent Francis Hughes. The State Ethics Commission later found reasonable cause to believe that that Worcester District Attorney Joseph D. Early and other officials had violated the conflict of interest law in their handling of the police report. And then we got footnote 2. So the Ethics Commission petition did not result in a finding of a violation. Then they got a hyperlink there. Separately, Kearney broke the story that State Trooper Leah Genduso had been hired by the Mass State Police despite having previously participated in a marijuana trafficking operation, and that she may not have disclosed that information on her application. And then, so that comes from the Pyle Affidavit Exhibit 2, Paul Tuthill, and that scandal scars Massachusetts State Police, WAMAC, Northeast Public Radio, noting that the blog Turtleboy Sports reported that years before she was hired, Genduso had been charged in a massive federal drug investigation. She escaped prosecution by agreeing to testify against co-conspirators. So that's footy 2. And then we'll just look ahead. Footy 3 is tbdailynews.com. And then he also cites or adds the link for Turtleboy's Live. So, I mean, what Pyle's doing here is establishing that Aidan is, in fact, a legitimate investigative reporter. So he's hearkening back to some of his stories wherein he has gone to great lengths and has, in fact, exposed corruption within the Massachusetts State Police. It gives weight to what he says. It gives credence to the fact that Aidan is, in fact, not just some loudmouth out there screaming. He's a guy who has done this for 13 years, and it's part of what he does.
And I think it begs the question, babe, if this was a situation where it's like the next person's suing Aidan. And they're like, well, he broke all this stuff in the Karen Read case or in the death of Officer John O'Keefe case. And later those people were arrested and the cops were arrested and they proved that there was like, if all those things actually got proven and it wasn't untrue, then it would be, how could they ever say, well, that wasn't petitioning activity?
100%.
Because that's the first question, right? Like whether or not it's petitioning activity, not whether it's true or not true. That's the second question.
All right. So I've got Charlotte saying it's Worcester. And then I've got Betty saying it's Worcester. Which one is it? I think it's Worcester. I'm always going to butcher Massachusetts names because frankly, you guys don't follow the rules of phonetics. It's fucking crazy. You guys are like, I don't know what you're doing out there over there in Mass. You're just butchering shit. It's unbelievable. As far as the names of people go and old stories from Aidan, I don't care. So, but the town names, I do care. So that I will always look for those things. I don't care about the other things in terms of old stories about old shitty cops. All right. So, Kearney's website and videos comprise a mixture of, hold on, I got to blow this shit up. It's way too small. Okay. Comprise a mixture of investigative reporting, analysis, opinion, and the kind of vituperative, abusive, and inexact language that is a hallmark of political speech under the First Amendment that comes from Watts v. U.S. Like many other media outlets, TB Daily News features advertising. Oh boy, does it. Oh boys, the advertising on that website is one of the most horrific things I've ever laid my eyes on. It's like, and I've seen some shit where like you can't scroll like a quarter of an inch before shit is blasting. It's insane.
I don't know if it's any different, like because now he's upped his game and he's changed some of his technology, so it might be different now. But
like it's that thing where if you pay to subscribe, the ads go away.
Oh yeah. If I was a fan, I'd pay to avoid those. I almost paid just to avoid them. The
shit is it's unreadable. Like I've tried. I'm like, you know what? I can't do this for more than 20 seconds. It's so fucking annoying. It's like pop-ups constantly. I'm like, oh my God. But I digress. So Kearney also requests donations and sells merchandise to support his work. So B, Kearney publishes articles and videos about the Karen Read case. Plaintiffs allege that in April of 2023, Kearney began receiving information through an intermediary from Karen Read, the defendant in a pending murder case in Norfolk Superior Court. Read had been charged with killing her boyfriend, Boston police officer John O'Keefe, by backing her car into him outside the Canton home of Boston police officer Brian Albert during the early morning hours of January 29th of 2022. So I already read through those footies.
April 12th.
On April 12th, thank you. 2023, Read filed a discovery motion to obtain Mr. Albert's phone for analysis. The motion attached numerous documents, including police reports. On April 18th of 2023, Kearney published a blog post about the Read case headlined, Canton Cover-Up, Part 1. Corrupt state trooper helps Boston cop cover up the murder of fellow officer, frame innocent girlfriend. The post is 70 pages long, including photographs obtained through Kearney's reporting efforts and screenshots from court pleadings and exhibits. Contrary to plaintiffs' allegations, Kearney wrote the post himself. Its content was not funneled by Read to Kearney. So
I wish he would have just added, did corrupt state troopers help Boston cop cover up murder of fellow officer and frame innocent girlfriend? Just the word did, but still.
Did.
Petitioning activity.
Petitioning activity. In his Part 1 post, Kearney sets forth the Commonwealth's theory of the O'Keefe killing and the evidence supporting it, alongside information from the defense's discovery motion. Based on his assessment of the evidence, Kearney concludes O'Keefe was violently beaten to death by persons inside Brian Albert's house, who then, quote, hatched an elaborate plot defame Read for killing him, end quote. As evidence, Kearney cites two damning facts set forth in the defense motion for discovery. These include that Brian Albert's sister-in-law, Jennifer McCabe, who was president at the Alberts' house, quote, had searched house long to die in the cold at 2:27 a.m. on the night O'Keefe died, long before O'Keefe's body was discovered at 6 o'clock that morning. Kearney reported that McCabe had taken steps to purge her phone of this inculpatory search and to delete her communications with Brian Albert. O'Keefe's phone, Kearney noted, had, quote, tracked him walking up and down stairs, end quote, between 12:20 to 12:32 a.m. Movement that would have been impossible if he was inside Karen Read's car or lying on the ground outside of the house, as the Commonwealth alleged. Kearney also reported that in the morning after Canton police arrived, quote, Brian Albert, a veteran Boston police officer and trained first responder, didn't even come outside, despite the fact that a crime scene was unfolding on his property.
Doesn't even look. He was passed out. I don't know what his dog was doing with all this.
I'm out of bed. I'm tired. You see me sleeping over here? Fuck off. They can all fuck off. What is going on?
What's the dog doing while all this is happening?
Yeah,
but these are all things you've heard everybody's,
right. We're not going to relitigate the case.
Nah.
She's been found not guilty.
Right.
So Kearney argues in part one that the killing was the subject of a cover-up, aided and abetted by members of the Massachusetts State Police, Canton Police Department, and the Norfolk County District Attorney's Office.
So
the person
here's the thing. This is why they tried to these defendants to not mention any of like the police shit in their complaint because, well, I guess this is this is not in the complaint. This is in their exhibit 3, because they're trying to keep it about what they said about the people. And you can't get to the police are covering something up, which is asking the government to do something. Can you look into official misconduct, bringing awareness to official misconduct without saying who engaged in the misconduct that they're covering up? So by essence, talking about the Shoulda-Been-House-Suspects is getting back to police misconduct, official misconduct. The government needs to do something, petitioning activity.
Boom. Nailed it. The person most responsible for the cover-up, Kearney stated, was MSP trooper Michael Proctor, who failed to speak to key witnesses and never applied for geofence data that would show the identities of every person in the house that night. Kearney then makes a direct plea for government action.
There you go.
Trooper Proctor, Brian Albert, Colin Albert, and Jennifer McCabe should all spend significant amount of time in jail, and 2 of them should be charged with murder. The Canton police chief and deputy chief should be fired. Every other person in that house should be charged with obstruction of justice, as they witnessed a crime and they never reported it. Following his part 1 post, Kearney wrote many more articles about the Read case in which he argued forcefully for her innocence. Were you going to say something?
I was just going to say it's important that they put it in there, because the what you're saying has to, like, typically petitioning activity is like a call to action, so that's why they're saying what he was saying should come of this is official governmental action. Charge somebody, investigate somebody, fire
do something.
Right.
Right.
And not just people go throw some at these people's house or whatever. I mean, he didn't actually say that, but it's all geared to a call for governmental action, petitioning activity.
Do something. I mean, that's it.
There's no doubt with Aidan. I don't think there is.
Me either.
Was it harassing? Yeah. Was it like in bad form and bad taste sometimes? Sure, but that's not what we're here to decide.
It was still petitioning
matter.
activity. It's
right.
still petitioning activity. Doesn't matter how ugly the words may have been. The fact of the matter is it was all petitioning activity. I mean, we said this before we even read this. Like we were always of the
We
mind.
haven't read this yet. Right.
No, I'm talking about like months ago. Like we were
Oh.
saying, like when we first started telling the people about anti-SLAPP and like what it is and explaining
Right,
what the
with the
petitioning
complaint.
activity is.
Right.
You know, I mean, we always felt Aidan had an incredibly strong anti-SLAPP
And that they
motion
hadn't
that,
alleged anything against Karen, really, which they then changed tune in their amended complaint. But again, I think it fits in petitioning activity, maybe not the one she asserted in defense of the original complaint, but one she can still assert several.
Yeah, for sure. All right. So following his part 1 post, Kearney wrote many more articles about the Read case in which he argued forcefully for her innocence. On April 18th of 2023, he published part 2 of his Canton cover-up series, in which he responds to commenters who had criticized his earlier post. In part 3, published on April 20th of 2023, Kearney criticizes the Norfolk DA, Michael Morrissey. The post is titled, Norfolk County DA says he will continue prosecution of innocent woman, Karen Read. Okay? Morrissey, Kearney writes, knows full well that Karen Read did not kill John O'Keefe, but he is pushing forward anyway for one reason, pride. He's not man enough to admit that his office is complicit in covering up for a murder. So every minute wasted on the prosecution of Karen Read is time, money, and resources that could be spent investigating and charging the people who killed John O'Keefe. It is an absolute joke and a disgrace that this politically connected hack of a DA is pursuing this. He should resign immediately and hand this case over to a competent individual. Kearney then calls on his readers to, quote, email Michael Morrissey at statemass.us. What is that, babe?
Petitioning activity.
Oh, yeah.
I mean, he literally, it's a call to action. And everything he's done always goes back to that because he did it so much.
CTAs, baby. CTAs. All right. So these posts mark the beginning of Kearney's years-long and ongoing campaign of investigation, advocacy, and petitioning surrounding the Karen Read case. The amended complaint alleges that Kearney had published 550 parts, 550 parts to his Canton cover-up series to date, as well as thousands of tweets, hundreds of blog posts, hundreds of YouTube videos, and countless other public statements across a variety of platforms. Take 3,
petitioning activity.
Petitioning activity.
All right. So let's switch. You're at what page?
Page 7, paragraph 3.
Okay. And then you can
did you find out whether our granddaughter is coming to this thing or no?
Oh, that's a good question.
Oh, no.
Because
I didn't mean to get you.
I don't know.
I didn't want to get you sidetracked.
Wasn't planning on it. It's a long drive, not very exciting for
All
her.
right, let's go. Keep rolling.
Well, I could have probably pushed him.
Time is of the essence if we're not missing it. All of our big kids are going skydiving today. Allie and I are going to go watch.
You said page what?
7, paragraph 3.
Okay. Close your eyes, people. Okay. Am I up?
You are up.
All right. Plaintiff Kearney's petitioning spawns the Free Karen Read movement. Plaintiffs admit, as they must, that Kearney successfully encouraged thousands of people to join his efforts to ensure justice in the Karen Read case and accountability for O'Keefe's killing. Petitioning activity. For example, on July 22nd, 2023, Kearney assembled at least 200 individuals to participate in a, quote, rolling rally through Canton focused on the case, culminating in a protest at the Canton Police Department. You can't get more petitioning activity than that. Once you're doing it in front of a government entity, it is petitioning activity. There's not even a question about it. So, sorry, guys. Oh, is Bob gone? Okay. All right, I'll go back. After 500 people joined Kearney at the protest in front of the courthouse. Wait a minute. Oh, sorry. I jumped a line. For example, on July 22nd, 2023, Kearney assembled at least 200 people focused on the, sorry, I was at the right spot. After 500 people joined Kearney at a protest in front of the courthouse, unquestionably, undeniably petitioning activity, on July 25th, 2023, he published an article that his readers to continue to speak out. Soon, Karen Read will be a household name across this country, and we are responsible for that. It has put public pressure on the DA's office and Canton and Judge Canoni to remind them that there are millions of us watching their every move. We will not allow them to frame and prosecute an innocent woman for murder while her killers remain free. We will continue to make our voices heard until there is real justice for John O'Keefe. Petitioning activity. Like, it is hands down, no doubt. Kearney undisputedly inspired hundreds of people to protest in front of the courthouse every day during Read's 2 trials. And they cite the complaint alleging, in words of protester, that, quote, Turtleboy was the reason there were people outside the courthouse every single day chanting "Free Karen Read" and wearing pink as a symbol of their support. This is what got me screaming petitioning activity in the first place. It was their complaint literally proved that this was petitioning activity. It's just insane to me. During Read's second trial, he drew protesters from as far as California and Georgia, and they stopped to take pictures with him. After Read was found not guilty, Kearney stated he would, quote, like to think that some of the evidence that was presented to the jury in court was a result of his journalism and his influence and his activism online. Kearney also applauded himself for conducting standouts, putting up billboards all over Norfolk County for Free Karen Read and making it impossible for people not to know about the case. And these are cites from the fucking complaint. They're alleging petitioning activity. They're alleging it. Observers of the trial shared plaintiff's assessment of Kearney's central importance in driving public discourse about the Karen Read case. And they're citing to Exhibit 7 of Brad Petrosian, Turtleboy factor. As Karen Read trial starts, Holden blogger influence on display. Holden blogger? Is that like, what is a Holden blogger?
Wait, stem from the blog of Holden's Aidan like maybe a town?
Oh, where he lives.
Oh, yeah. Okay. That's what I'm guessing. I don't know, though.
It's got to be something that it's obviously referring to Aidan.
I think it's like the town he lives in, maybe.
So what do we say this is? Worcester?
Worcester. Like, I think Worcester's the best one that I saw.
Worcester.
Yeah.
Okay. Worcester Telegram, April 16, 2024. Quote, while the murder allegedly occurred in Canton, the publicity that has turned it into a regional
oh my
and
God,
national...
they're saying Worcester.
What are they saying?
Worcester. Kind of, so like rooster. Rooster.
I got it, babe. I'm from the East Coast. I can handle it.
Oh, yeah, you nailed it, babe. You're crushing all the Boston names. Like, nailed it. Worcester.
While the murder allegedly occurred in Canton, the publicity that has turned it into a regional and national fixation largely stemmed from the blog of Holden's Aidan Kearney. So yes, he was in Holden. And then you have Catherine Elton. She said,
"Damn it! People are saying it's. See, I keep seeing the Worcester. That's the way I said it. I like the Worcester.
Worcester.
People are saying it's Worcester. Worcester.
Worcester.
Why don't you all just land on what it is? like as a general proposition,
Worcester.
and let us know. The chat's going wild. Like they all say different shit. Yeah.
Worcester.
All right, let's keep
Worcester.
rolling. Worcester.
Worcester.
Boston.
All right, let's
Worcester.
stop.
All right.
Okay, so now you've got someone from Boston Magazine, Catherine Elton, Free Karen Read blogger Turtleboy will not go quietly. And the quote is almost single-handedly, okay, through relentless blogging and YouTube streaming, Kearney upturned public perception of what seemed like an open and shut case, casting a thick cloud of doubt on the workings of our justice and law enforcement system. Go to hell, plaintiffs. Go to hell. If the judge doesn't throw this out, I don't know what's going on.
Tell him, babe. Tell him.
Then we've got someone from the Atlantic, Chris Heath. Turtleboy will not be stopped. Quote, there's a solid argument that the whole public discourse around the trial, not just the heightened interest in it, but the galvanizing of a small movement of people committed to defending Karen Read against what they believed was an imminent injustice, was catalyzed mainly by Kearney's interventions.
Truth.
I mean, he's doing it.
Did the damn thing.
Yes. Participants in the Free Karen Read protests agree. Then you got an affidavit of Rita Lombardi and Paul Cristoforo.
Do it, babe. Do it.
So, and you've got some participants who are all attributing it as it should be. I mean, as is the only answer to Aidan. It's you, babe. Okay. Here, so get yourself to 4, and we're gonna switch out.
Oh, you want me to add mine?
No, it's fine.
Yeah, just scroll for me, girl.
I'll scroll for you. Just in neither of us paying attention.
All right. So Kearney's writings lead to a Canton special town meeting and an audit of Canton PD.
Oh, wait. Government action was taken?
Oh, no.
Wait, the government did something because of all the public pressure that was coming from his activities?
Oh, my God.
Oh, boy.
Bukaki.
Don't say that.
Oh, my God. So Kearney's activism did not just inspire protest. It encouraged Canton residents to propose, vote for, and implement a measure to bring increased oversight to the Canton PD. In direct response to Kearney's coverage, residents began to speak up at meetings of the Canton Select Board to raise questions about the honesty and professionalism of the Canton PD and to question the actions of the Select Board member, Chris Albert, the brother of Brian Albert. That comes from Lombardi's affidavit. Before its meeting on September 26 of 2023, the Select Board suspended the open comment portion of future meetings to allow emotions to cool. All right, you got to scroll up, baby cakes.
Oh, sorry.
And maybe pull the GA Cat Mom gifting membership thing down.
Oh.
Spectators showed up anyway, some with tape over their mouths and others with signs reading "Justice for John and Karen" and "Stop Corrupt Offices." In the fall of 2023, Canton residents placed an article on the warrant at a special town meeting to conduct an independent audit of the Canton Police Department.
Read footnote for it now.
Where was footy for? I didn't see it.
It
So
doesn't
on
matter.
October 27, 2023, in response to the criticism fomented by Kearney's reporting, the Canton Select Board announced that it would conduct 2 reviews of the Canton Police Department's operations. Wow. I mean, that's like petitioning activity that like worked.
Right.
It worked. It actually worked. And one examining the department's policies and procedures and the other auditing its evidence room, according to the Canton Citizen. Quote, both reviews have been the subject of numerous resident requests at select board meetings following the death of former Boston police officer John O'Keefe. A select board member stated at the meeting, quote, we have heard the individual concerns of our residents. Petitioning activity.
I mean, we have heard the individual concerns of our residents. And how is the only way you're even hearing? How do your residents even know to raise concerns?
Listen, if you're going to flip open Merriam-Webster and look under the definition of petitioning activity,
it's a picture of Aidan.
It's a picture of Turtleboy. Like Aidan's mug's going to be right there. All right. So, wait, I think we read that part, right?
The sentence. Wait.
Yeah, I think I was.
The sentence
at the
starts
co-sponsor Rita Lombardi states in her affidavit that she was spurred to take action to propose the audit because Kearney's reporting. In an article on November 10th, Kearney encouraged every citizen of Canton to be at Canton High School on November 20th for the special town meeting. Vote yes on the audit and bring as many friends and family members with you as you can. I mean, textbook petitioning activity.
Here's the point that and these are all things that they're adding because it is important that the court get context. That's why I'm saying, sure, there were some times where Aidan's just screaming that someone's a this or that and they're murderers and they should all be gawked at and know the world knows. But it is all.
Wait, I'm sorry to interrupt you. There was a hearing in, Tracy just texted us in 5 minutes on Karen Read shit.
Where? Which hearing? Which case?
It's Boston 10. Like I don't know. Let's see.
Thanks, Tracy.
Tracy's the best. Karen Read case motion hearing. So I don't know. It can't be the federal case, obviously, because that would never be streamed.
All right. Well, you pull it up on your computer.
Okay.
And I'll read this while you get it up because I just want to finish that sentence and my thought. So I'll just read the sentence and then I'll finish my thought. So then we'll start with 5 when we return. On November 20th, 2023, the special town meeting voted 903 to 800 to approve the warrant article despite the unanimous opposition of the select board. So this is what I was getting at. Yeah, they can pull out little bits of something that Aidan said that doesn't appear as direct petitioning activity. It doesn't see, did he ask the government to do something or did he ask people to do something to get the government to do something? But all of his shit comes back to what he was saying time and time again. Get out and vote. Tell your, let everybody know we're watching and the government's not investigating and the officers are covering things up. Get out and go show up at this, show up at that. He was always trying to get the government to either not charge an innocent woman or reopen, expand an investigation into other possible suspects and to official misconduct and to prosecutorial overreach. All of it, always, no matter what kind of bullshit he was saying in between. Period.
All right, I got it ready to rock and roll. And it's starting in 3 minutes, 25 seconds.
So should we keep reading or should we stick it up?
Let's
wait till you see
right now
something.
it's still just that picture, but
all right, but it's playing, so you'll hear it in your ear when it starts.
Yes.
Okay.
Well, it's still just the thumbnail.
So I'll keep reading so that you're paying.
Keep rolling.
Yeah. Okay. So 5. Each of the articles and videos identified in plaintiff's amended complaint was part of Kearney's petitioning campaign. Okay. This is where it's all at right here. I'm going to go to footnote 5 before we get to it. Actually, the audit report released in April 2025 criticized the Canton police for several failures of procedure at the O'Keefe crime scene, including the failure to photograph O'Keefe's body where it was found and to interview Jennifer McCabe and Brian Albert on camera at the Canton Police Department. This report doesn't exist but for Aidan, period.
And his petitioning activity.
Exactly. The audit also criticized the Canton Police Department for leaving the scene unattended for 10 hours after discovering O'Keefe's body. The auditors recommended that Canton police officers undergo additional training in crime scene management and interrogation. that patrol vehicles be equipped with crime scene kits, that the policy be changed to prohibit officers from using personal phone calls to take crime scene photographs. A copy of the report's available at, and they put
so much petitioning activity. It's just
creating change.
Like literally.
And you cannot separate that. I'm sorry. You cannot separate that from things like, you know, Jennifer McCabe is a first-degree murderer. If it was words of Aidan, you know, I'm just focusing on Aidan right now because they had different, you know, different approaches to what they were doing. All right, Aidan's is very directly petitioning activity,
like spot on. Like
right.
I said, flip over the Merriam-Webster, look up the definition of petitioning activity. It's Aidan's mug right there.
All right, a list of all. Oh, okay.
60-second countdown, babe. 60-second countdown.
All right. Well, as soon as it starts, stick it up. Put it down there so you're ready to stick it up. Like add that, share that screen.
Yes, ma'am.
So plaintiff identify 37 allegedly defamatory publications that Kearney published about them, consisting of 14 written statements and 23 allegedly defamatory videos. A list of these articles and posts identified as defamatory is set forth in Exhibit 16 to the affidavit of Jeffrey Pyle. All right, footnote 6. The list does not include every video or writing identified in the amended complaint. At least they know it's an amended complaint, for God's sakes. Plaintiffs reference some of them in an effort to show that Read and Kearney worked together as opposed to identifying statements that harmed the plaintiffs. Yeah, because they're idiots. I mean, I honestly, some of what they're doing is just it's idiotic that you've got, you know, smart, accomplished attorneys just throwing bullshit around.
Oopsies. All right, we'll just keep it
playing though, right? You're sure?
Yeah. Well, they haven't started the stream yet.
Started anything to play. Okay.
Yeah, they'll kick it on. You keep.
All right.
reading.
Well, then let's just talk. You want me to read while people are looking at that?
Sure. Karen's looking stern there. She's looking very serious. Saying, I smell bullshit.
So I'll summarize. So the videos identified as.
Look at him. What a guy. What a guy.
So they said the videos identified as defamatory in the amended complaint as defamatory total approximately 58 hours. Certain petitioning related segments of these videos are summarized in a chart attached to the Pyle affidavit as Exhibit 29 with available hyperlinks to videos. Wow. They really did some shit. As of the date of service of this motion, plaintiffs have not complied with the court's directive to supply the allegedly defamatory videos on a thumb drive. They're not, because we said it before. Who is going through all of these hours? Like somebody did something and then they fucked up and they didn't have it all, you know, like extract it out, make a separate thumbnail or make a thumbnail and give the exact specific, you know, start and time, period. All right. Where was I? Oh, okay.
Yeah.
Each of the allegedly defamatory publications of which plaintiffs complain was part of Kearney's campaign to ensure that justice was served, to encourage the prosecution of plaintiffs for the crimes related to John O'Keefe's death.
Interesting.
What?
Some channels are reporting that today's hearing will not be live streamed. Well, we'll keep plugging along. I've got it down here. If it is, we'll throw it up. If not, you know, we're in the middle of some shit. So win-win either way.
All right. So, and this is important. Okay. So he's saying that his campaign, he gave 2 reasons. I wish he would have given a couple more. Well, I guess these are a couple more. These are what he's saying his activities were geared to as far as bringing about, you know, asking the government to do something or getting people, the public, to ask the government to do something. Those goals, they further those goals in several ways. One, by reviewing the evidence of Read's innocence and plaintiff's guilt in the O'Keefe killing. Two, criticizing the police and the prosecution for their handling of the case. Three, calling for dishonest or corrupt police officers to be fired or prosecuted. Four, expressing opinions about the veracity and significance of trial testimony. And five, encouraging public participation in the case. So then you have the trials is paragraph 6.
All
It
right,
says,
all right. Hold on. Let's go.
what's happening?
Yep. I'm putting it up.
Well, all right, minimize and make the sound play.
Okay. Hold on. Sound on.
Read this, so apologize. I'm gonna read it down.
Minimize, make it bigger. What are you
I
doing?
will. I will. Hold
Prior to
on.
the hearing, he had contacted the base asking about the inquiry we discussed on the hearing June 22nd. On June 23rd, he received a call from a private Jordan Rosa in the legal service department at Fort Jackson. And he indicated he was returning a call to place last week. He made the request.
Not available.
To Private Rosa about getting access to Mr. Albert, who, by the way, at this time, shortly after the hearing, he's now in basic training. So the 10-week basic training, the first 3 weeks was the initial school. He passed that. He's now basic training at Fort
Wrongful
Jackson.
death case?
Private Rosa indicated that
It's about Colin. Motion to compel.
he was unaware of what process it would have. On June 26, 2026, Attorney Maddie received a call from Sergeant Lucas Vaughn at the Trial Defense Services at Fort Jackson. He indicated he would asked about getting access to him from basic training for purpose of subpoena. He was told, quote, "That's not happening," is what the sergeant said. He speculated that the only possibility would be a 30-minute phone call. He said that the training regimen for basic training is very specific and condensed. He advised that eating and sleeping are the only breaks that the trainees receive. He said that following his graduation from basic training or advanced infantry training, which is what he's doing, he'll be a permanent party member at a duty station. He's more likely to have access for a deposition at that time. On June 26th, Attorney Maddie received a correspondence from Colonel Jacqueline DeGain, basically suggesting that he would need the identity of Colin's commanding officer. We've now made several requests of Colonel DeGain for the identity of the commanding officer. Those have so far gone unanswered. So that's the current state now. We've had several calls with a private sergeant colonel. So far, don't have the information. It's been suggested to us that during basic training, they control their life.
Can you boost it? Hey, you muted it.
I know.
That the only breaks they get are sleeping and eating. And it's part of the turning them into a soldier. So that's the kind of information we have now. I believe he's in week 2 or 3 of basic training.
Okay, thank you. Attorney Seligson, is
All right,
that
hold on.
news to you? Or have
Reduce your sound, babe.
you patience
Babe, hold on.
with
I would think it's news to
Hold
him
on.
because he might not know. Because we were preparing this to get, and then we got the notice about coming today. So I kind of ran today. We had responded on the search terms.
Okay.
We didn't talk about search terms for Colin Albert.
Okay,
So we hadn't had a chance to fill it
why
in.
don't you reduce that to writing and let Attorney Seligson know so he can be prepared to make an informed response.
Thank you, Your Honor.
He's talking about it at this time.
Oh, Lord.
No, it's fine. My first screen didn't have
All right,
the
but it's
boost.
not up.
Oh, shit.
And you got to reduce your sound so they can turn their volume up. I put myself at 64. Everyone's leaving. They're going to other people to watch this.
All right, hold on.
Don't go. No one's better than us. Wow.
Hold on, dude. Okay, so let's see.
Do I need to come in there and help you?
No, babe.
I'm poking at him, so don't blame him right now. Ugh.
All right, hold on. Okay, I got it. All right, sorry.
So we'll see it soon.
Yes.
Oh.
It's not like we can't fucking rewind it 2
I
seconds.
know, but
No, the problem
This
was
is a
that
civil-
on
Okay,
my first
rewind it.
screen, the
26.
first screen didn't have the
Okay.
2 times boost.
So
That was the issue.
that's all right.
All right.
your opposition
Still sounds like
uses the
shit.
term fishing expedition,
Oh.
which that's great if
What?
it's a criminal.
Go back until the judge starts talking. For
Okay.
the very first time the judge starts. Hold on.
That's working productively.
All right. Attorney Tuxbury, you're welcome to
A
stay.
little more. We
On a
didn't hear
Friday
that.
afternoon, you're welcome to leave too.
I appreciate the search terms.
Okay.
We've been talking about search terms from Colin Albert.
Okay.
We haven't had the chance to fill it in.
Why don't you reduce that to writing and let Attorney Seligson know so he can be prepared to make an informed response.
Thank you, Your Honor.
Just talking about it at this time.
That's right. I wasn't aware of the mechanics of where he is, but we are working productively on the search terms and narrowing the scope of the subpoena.
Okay.
So that's working productively.
All right. Attorney Tuxbury, you're welcome to stay, but on a Friday afternoon, you're welcome to leave too.
I appreciate that, Your Honor. I think I'll take the invitation to depart. Enjoy the rest of your day, Your Honor. Thank you very much.
Thank you.
Oh, now maybe they're shifting gears.
So the other remaining motion is the plaintiff's motion to compel Ms. Read to produce additional information and discovery.
Medical
And
records.
I've read everything. Mainly the issues relate to medical information and financial documents. And I guess I'll start with Attorney Seligson to ask you, given the,
Michael Proctor.
you know what the standard is, because your office has quoted it a number of times in your motions to compel, that parties may obtain discovery regarding any matter not privileged, which is relevant to the subject matter involved in the pending action, whether it relates to the claim or defense of the party seeking discovery or the claim or defense of any other attorney. Your opposition uses the term fishing expedition, which that's great if it's a criminal case, because that's where fishing expeditions are
Not allowed.
discouraged
Right.
and not allowed under Rule 17 under the criminal rules. But this is a civil case, and Rule 26 is very broad. So without getting into the specifics about the medical, why isn't merely the provisions of Rule 26 applicable here? And why shouldn't they require production of the information the plaintiffs request?
Your Honor, with respect to seeking her medical records for a 2-year period, even though the term fishing expedition generally applies in a criminal case, I don't understand why they would need to understand her health in 2020, 2021.
How about 2022?
That's different. Perhaps they, if they narrowed it, we could reach an agreement about something in confidence. But
Did you have discussions about narrowing it?
Mhm.
Did you two have discussions, or were you talking with someone else on these?
I spoke to Attorney Rosenberg.
but
Hang on. So the next issue relates to the financial documents. And there has been certain information provided. There's been certain information redacted. Have you had discussions about that?
we have had discussions, Judge. The redactions are for transactions that are not specifically asked for in the document request. So what we did was we produced the bank statements and credit card statements for the 2 dates that were asked. We blacked out and redacted account number and private information.
But somewhere you cited attorney-client privilege, I think, on that issue, which I had difficulty following.
Attorney-client privilege? I don't believe we asserted attorney-client privilege, Your Honor. If there is a payment to counsel, then that's what that would pertain to. And if that's reflected on the
Somehow I don't think counsel were getting paid by credit card at that
well,
time. Just a wild
Debit card.
guess.
but there's a bank statement as well, Judge. So I don't have it in front of me with all transparency, but that would be the reason for it. The transactions that they asked for on the dates in question We've given it to them. But just this broad wondering what else is out there and what else my client is spending her money on, it's not relevant, Judge. And she's entitled to some privacy on that front.
Right, but again, Rule 26 is so broad, it's not necessarily up to the party to say it's not relevant, because the standard is it might lead to the discovery of admissible evidence, right? So if we had a party every time just saying, well, it's not relevant, forget about it.
But if they're asking for transactions, if they ask for transactions on January 28th and January 29th, and the statement covers January 1st to January 31st, we've redacted out things that aren't specifically asked for.
All right, well, so we'll give Attorney Diller a chance. Do you believe that there was information redacted on the 2 days in question that is relevant?
Respectfully, I apologize. I don't have that redaction in front of me. I know that as it relates to anything on those 2 days, I believe there should be no redactions. And if things need to get filed that should be protected, we are amenable to redacting those
Don't
out.
have it in front of you. I'm sure you have a copy there.
I don't have it in front of me either, Your Honor. It's his motion.
Come on, people.
My motion is the interrogatory is a separate question from a production of document. So in the interrogatory still remains unanswered. The production of document is a separate whole issue that we have an outstanding issue for production documents. I acknowledge that there was something that was turned over through production of documents relating to financial transactions. Our request asked them to articulate under oath, every one of the transactions that she had and the institutions that she filed them for those 2 days so that we can track both her whereabouts and also whether it's reasonably calculated, lead to discovery of admissible evidence, which is significant for just a 2-day period of time.
In response to that, Your Honor, as we are entitled to under the rules, we are entitled to say, here are the documents that answer your question with appropriate redactions for things that are not asked for in the interrogatory.
Let's go back to the medical issue for a second. Doesn't sound like the two of you have spoken about the medical issues. And you suggested there might be a limited period of time that there could be some agreement on. So I'm going to ask counsel to go talk about it. And I'm going to ask counsel to keep in mind the reference by Mr. Diller to the testimony from the criminal case in the forensic scientist relative to medications. Cited on page, it's in their reply, I think.
Page 2 of the reply, Your Honor.
So I'm going to give you a little time to go talk about that. And hopefully you'd also take the time to talk about the other financial records. All right? If you can't do it, you come back, I'll hear you, and I'll issue a decision at some point. Okay?
Okay. Thank you, Your Honor.
Great. Thank you.
Court, all right.
So I have to
All
say,
right, no, keep it up. Keep it up. We'll go
Oh.
back and listen. All right, so this is very simple. This doesn't require a lot of explanation. As far as Karen's medical records,
From a production.
go figure the shit out between yourselves. Like we said all the time, judges in civil cases expect the attorneys to try to work shit out before they come whining to the court. All right, so let's hear what they said about Colin.
So he can.
He advised
All right, so this is the excuses they're giving for Colin.
hearing he had contacted.
Duxbury relative to the information about Mr. Colin Albert.
Certainly, Your Honor. I read this, so I apologize. I'm going to read it down, what Mr. Attorney Maddie did. So prior to the hearing, he had contacted the base asking about the inquiry that we discussed on the hearing June 22nd. On June 23rd, he received a call from a private Jordan Rosa in the legal service department at Fort Jackson. And he indicated he was returning a call to place last week. He made the request to Private Rosa about getting access to Mr. Albert, who, by the way, at this time, shortly after the hearing, he's now in basic training. So the 10-week basic training, the first 3 weeks was the initial school. He passed that. He's now basic training at Fort Jackson. Private Rosa indicated that he was unaware of what process it would have. On June 26, 2026, Attorney Maddie received a call from Sergeant Lucas Vaughn at the Trial Defense Services at Fort Jackson. He indicated he was asked about getting access to him from basic training for purpose of subpoena. He was told, quote, "That's not happening," is what the sergeant said. He speculated that the only possibility would be a 30-minute phone call. He said that the training regimen for basic training is very specific and condensed. He advised that eating and sleeping are the only breaks that the trainees receive. He said that following his graduation from basic training or advanced infantry training, which is what he's doing, he'll be a permanent party member at a duty station. He's more likely to have access for a deposition at that time. On June 26th, Attorney Maddie received a correspondence from Colonel Jacqueline DeGain, basically suggesting that he would need the identity of Colin's commanding officer. We've now made several requests of Colonel DeGain for the identity of the commanding officer. Those have so far gone unanswered. So that's the current state now. We've had several calls with a private sergeant colonel. So far, don't have the information. It's been suggested to us that during basic training, they control their life from waking up to going to bed. That, like I said, the only breaks they get are sleeping and eating. And it's part of the turning them into a soldier. So that's the kind of information we have now. I believe is in week 2 or 3 of basic training.
Okay, thank you. Attorney Seligson, is that news to you? Or have you had communications with?
I would think it's news to him because he might not know, because we were preparing this to get, and then we got the notice about coming today. So I kind of ran today. We had responded on the search terms. We did talk about search terms from Colin Albert.
Okay,
So we haven't had the chance to fill it in.
why don't you reduce that to writing and let Attorney Seligson know so he can be prepared to make an informed response.
Thank you, Your Honor.
Just talking about it at this time.
That's right. I wasn't aware of the mechanics of where he is, but we are working productively on the search terms and narrowing the scope of the subpoena.
Okay,
So that's working productively.
all right. Attorney Tuxbury, you're welcome to stay, but on a Friday afternoon, you're welcome to leave too.
I appreciate that, Your Honor. I think I'll take the invitation to depart. Enjoy the rest of your day, Your Honor. Thank you very much.
Thank you. So the other remaining motion is the plaintiff's motion to compel Ms. Read.
All right. So that's that. So basically, Colin, they just supplied him with information. He's in basic, whatever. You know, and again, judge is like, work your shit out. If you can't work your shit out, come in front of me and I'll order something. So that's the case for both situations. It was interesting, though, to hear him say what we're always telling you. Fishing expeditions and civil, it's allowable. That's what it is. You're going to get way more discovery. I don't know how many times I have to say it. You're going to get way more discovery in civil cases than you are in criminal. That's just the facts. That's just the facts. So ultimately, if they can figure out as far as Karen's medical records, if they can work something out in terms of how far back they want to go or they're willing to go, then the judge isn't going to have to order it. They'll just produce it. If they can't come to an agreement on that, then the judge is going to hear it and then he'll rule on it. And then once he rules, it's in stone. If he says you're going back to 2020, then they're going back to 2020, you know? And then as far as the financials, again, it is a fishing expedition, but they're going to be able to dig, you know, and it goes both ways. This is very, very much a two-way street. So, you know, what's good for the goose is good for the gander. Any kind of shit that they're going to be requesting from the other side, it's the same rules apply. So this isn't a one-way street. It's definitely a two-way street. So basically the judge, if we were to summarize what happened in this brief hearing today, it was, okay, we just learned about the new Colin shit. Turn that over to Seligson. Let him take a peek at it. Try to work some shit out. And same with Karen's stuff. Like no decision was made. Nothing was ordered today. Try to work your shit out. If you can't figure it out, come in front of me. I'll make an order. So that's that. All right. So that was relatively uneventful. That's how I would describe that. All right. I want to pull up the document. We're going to go back to it. let me see here. Let me shrink this down. Okay. Okay, let me find it. Where the hell is it? All right, bear with me, kids. Okay. All right. Okay, got it back up. I can't remember what page we were on because Allie was doing it. All right, let's see. I'll figure it out. I don't know where she went. She gone. No, we're not at 6. Oh, you mean number 6, not page 6. Okay. It's all right. I'm pulling it up. You late. All right, let's go. All right, so she says we're at 6.
All right. So here's what we're going to do, though. We're going to finish this, and then we're going to save their whatever their bullshit opposition is until we get
The
his
ops.
answer, until we get the reply. Because I think this is such a strong argument, and there's no point in reading their opposition until we get Aidan's lawyer's response to it. So
Yeah. All right. So Karen Read's trials. The first trial in the Commonwealth v. Read began on April 29th, 2024 and ended in a mistrial on July 1st of 2024. A retrial began on April 22nd of 2025 and ended on June 18th with a not guilty verdict on the charge of second-degree murder. At both trials, the court permitted the defense to present evidence that plaintiffs Brian Albert and or Brian Higgins were third-party culprits who killed John O'Keefe. The court made these rulings after determining that Read met the evidentiary standard to mount a third-party culprit defense. Yeah. Argument, the anti-SLAPP law, 59H, protects the right to petition the government for redress of grievances. So under 59H, a party may file a motion to dismiss. Oh, wait, we had footnote 7. As of the date of service of this motion, plaintiffs have not complied with the court's directive to supply allegedly defamatory videos on a thumb drive. Oh, by the by, they haven't turned that shit over. All right, so 59H, a party may file a motion to dismiss if civil claims against it are based solely on its exercise of the constitutional right to petition. So the statute provides powerful procedural protections requiring the speedy dismissal of such claims unless the targeting petitioning was devoid of any reasonable factual support or any arguable basis in the law, coming from Bristol Asphalt, as we just saw. To me, Karen's not guilty, and the fact that Kearney allowed the third-party culprit stuff in, this thing's dead in the water as to Aidan.
dead in the water on count 2. No,
Yep.
to both of them. If they
I-
get to stage 2, not count 2, stage 2,
Right.
once they find it's petitioning activity, there is no way for these plaintiffs to overcome.
Dunzo.
Right.
So an anti-SLAPP motion is addressed in 2 stages. At the first stage, the motion's proponent here, Kearney, must make a threshold showing through the pleadings and affidavits that claim that the claims against him are based on his petitioning activities alone and have no substantial basis other than or in addition to the petitioning activities, citing several cases. If a special motion proponent meets this threshold burden, the analysis proceeds to a second stage at which 59H requires allowance of the motion unless the special motion opponents, here the plaintiffs, quote, show that Kearney's exercise of his right of petition was devoid of any reasonable factual support or any arguable basis in the law and caused actual injury to the special motion opponent, citing Thorell. So proving that petitioning is devoid of any reasonable factual support or any arguable basis in the law is a difficult task. So the anti-SLAPP law provides that if a court grants a special motion to dismiss, it shall award the moving party costs and reasonable attorney's fees, including those incurred for the special motion. So 59H says the award of attorney's fees is mandatory.
Mandatory.
Mandatory. You're
Oh,
paying Aidan's
God,
fees.
I hope they get slammed.
Oh, that would
Just
be
because
so
this
tasty.
this was ridiculous. Adding the defamation thing was just stupid.
Stupid. So a denial of an anti-SLAPP motion is appealable under the doctrine of present execution.
So they're
And
saying,
is-
hey, this isn't over yet. No, whatever you do, this is continuing.
Exactly. And is reviewed de novo. Okay. So 1, plaintiff's claims against Kearney are based solely on his petitioning activities. Plaintiff's claims against Kearney are based on statements and acts that fall well within the broad ambit of anti-SLAPP laws protection for a party's exercise of his right of petition. So Kearney is being sued solely for writing and speaking about the evidence in a pending criminal prosecution, rallying public opposition to the proceeding, and reporting on the facts that were likely to and did inspire public participation in the matter. And for arguing that the authorities should charge plaintiffs, not Karen Read, with the underlying crime. All of that conduct is protected. What, babe?
Petitioning activity.
That's right.
Point being, again, my whole thing, I think our whole thing is like the manner of the petitioning activity, the manner of conduct, the way he went about it. They might not like that. And it's not your traditional, petitioning activity, but it cannot be denied. It just cannot be denied. And I don't think picking out 1 or 2, of the more egregious methods that he used, the more offensive methods that he used, converts his activity into anything other than petitioning activity. Like, it's still petitioning activity. It's just in a method that you think sucks, and that maybe a lot of people think sucks, or had moments of huge suckery. But,
No, suckery I made up the other night. So the definition of a party's exercise of its right of petition in the anti-SLAPP law is very broad. Okay. It includes several elements that squarely apply to Kearney's alleged speech and actions here, including any written or oral statement made in connection with an issue under consideration or review by a legislative, executive, or judicial body. Any statement reasonably likely to encourage consideration or review of an issue by a legislative, executive, or judicial body. Any statement reasonably likely to enlist public participation in an effort to effect such consideration, and any other statement falling within constitutional protection of the right to petition the government. In order to determine if statements are petitioning, courts consider them in the overall context in which they were made. Kearney's writings and statements constituted petitioning first and foremost because they were, quote, reasonably likely to enlist public participation, proofs in the pudding there, concerning the O'Keefe killing and the Read prosecution. 59HA. Or 59H. Kearney identified what he believed to be a massive travesty of justice, explained in detail the reasons for that conclusion, and inspired his hundreds of thousands of followers to take action to stop it, including by emailing and protesting against DA Morrissey and the police, protesting at the courthouses, and participating in public standouts against the prosecution.
I'm sorry, I'm sitting in a backless chair and realizing I got to strengthen these muscles because it's really starting to hurt.
Okay.
Like, I might as well be sitting at a bleachers on bleacher seats with nothing at your back, though.
All right, here's our issue, babe.
I know. So we've got to run.
We'll
through
never
this quick.
finish 20 more pages before, like.
Oh, it's 34. I thought it
Oh,
was
yeah.
24.
Oh, yeah.
So you know what? We got to pick a place to stop, and there'll be a part 2.
All right. Yeah. Part 2's all right. Good.
All right. Well, it seems like this is the place because it's not stopping anytime soon.
We could go. Do you want to let's make it through section
Page
1.
16.
Yeah.
All right. Do it
Section
quick.
1. All right. I can't even
Because I
remember.
really don't want to miss it. That would
No,
be
I want
horrible.
to see it. I want to see it. Yeah, they'll never let us live it down.
And
It'll be.
I want to see the driving time here because I think
Where were
it's-
we? I can't remember.
I don't know.
Let's see.
Chicagoland skydiving.
Okay, I think this is it. Okay, so Kearney's writing and statements constituted petitioning first and foremost because they were reasonably likely to enlist public participation concerning the O'Keefe killing and the Kearney prosecution. Kearney identified what he believed to be a massive travesty of justice, explained in detail the reasons for that conclusion, and inspired his hundreds of thousands of followers to take
You gotta
action.
wrap
to
it.
stop it. What do you mean?
Yeah, it's a 40-minute drive.
She said 35 minutes. Like, what do you mean? Wrap it like now?
Yeah, because don't we need to bring our stuff with us or we're going to come all the way home before we leave?
All right. So I'm going to screen grab exactly where we're at. No, we're going to have to come back.
All right. Well, let me do these supers real quick.
That's facts.
And look what was exposed. They hate it. Cheers all. That's from Under Your Scars. Julie says, I'm behind on the live, but we had a car dealership that had a commercial with the tagline at the end, bring your wife in and we'll dick her. Neil Norton Cadillac in Peoria, Illinois. Wow.
Yep.
That's a little much though.
Peoria knows.
Jody Phillips says, I'm in the UK and live in Worcester.
Oh, and before people dip, okay, over at Seeking Justice Discord, all right, you guys have to make sure to go over there because tomorrow night at 7 p.m. Eastern, it's trivia night.
Oh,
Woo! So
and
Seeking
that's with
Justice
our very own
Discord
Tracy.
channel, our very own Tracy is working feverishly to come up with the most difficult, incredible trivia questions you can possibly imagine. And fun, of course. Fun is to be had. So their true crime, movies, music is the subject matter. I mean, can you get three better things than music, movie, and true crime? I mean, it's like a dream scenario. So make sure you're going over there for trivia night. It's their first one. Oh, wait, let me see. There's a grand prizes are going to be available. Wow. Seeking Justice magnets, Seeking Justice stickers. Ooh, the big one, the Seeking Justice bag. Let's go. Let's go. So everybody gets subbed over there.
The lawyer you blow says, I mean, I don't know. Does he like the lawyer, you know? And that's supposed to be like,
I don't know.
Like in support of him, but it
I have
doesn't
no
sound
idea.
good.
I don't know.
Wista and Wasta. As
Wista and
wussy.
Worcester.
Oh,
Worcester.
and Worcester. Wista and Worcester are acceptable.
Worcester.
Look up Adam Sandler's Toll Booth Willie, copyrighted.
Toll
skit,
Booth.
a Toll Booth Willie. Oh, I remember that, I think. A skit about Worcester with a proper pronunciation. That's wild. I'm gonna do that on our drive tonight. Where we are going for the grand opening. Wait a minute. For the grand opening in what part of Iowa? Davenport, Iowa. Of Station 7, Firehouse Station 7. Station 7.
Gen 1D did us super solid and sent us a clip.
In the middle of advertising our very closest friend's brand new opening of his amazing venue, you chimed in about the Adam Chandler thing. But we call it the Firehouse, but I think, is it officially called Station 7?
It's Hose Station 7. So he bought a 100-year-old firehouse and converted it into the dopest venue.
We can't even show pictures of you to you right now because until the grand opening, nothing's public. But this thing.
Oh yeah, no, that's not true. Go to Instagram.
Is?
Yeah, go to Instagram for Hose Station 7, and he's got a video up. The place is so
you got to
cool.
do it. And we'll be there tonight. Maybe you'll see some videos of us. Hopefully
Adam
not.
Chandler. Yeah, I heard that too. Nola's for livers.
All right,
I
but
think
anyway,
it
it's amazing. It's the sickest thing you'll ever see. He converted the old firehouse. There's actually an old fire truck as the DJ booth, and the whole thing is pimped out. It's like nothing Davenport has ever seen. This guy is legit. He's long time in the music scene, and he's taken his skills and his connects as far as bands and acts they'll have right to Davenport,
Oh, yeah.
Iowa.
The great Quad Cities. Not
Yes.
that Nikki sent us 5. This issue feels so old at this point, but I wonder if they came to an agreement regarding personal information. I mean,
Might have.
who knows? Like I'll always want a definition of what he meant there. What does that mean? Thank you so much, Megan, or maybe Megan, maybe not. Member for 9 months. The tech wizardry keeps me here. Y'all are great. Aw, thank you. We appreciate that. Merlot, 1958. Through 10 at it. Thanks for the coverage. Thank you for your generosity. We appreciate that. And Music to My Soul, $5. Gildea, Karen's discovery requests are overly broad. Also, Gildea, Rule 26 in civil cases is very broad. Make sense.
I know. You're completely on point. Someone's going to clip those two things, put them together, because well, the other was a written order, not, I don't think, oral, but I don't know. But point taken.
Yes.
All right.
And then
GA
GA Cat Mom, member for 10 months, Diller knows he has a loser case and he wants things hard.
All right. We love you guys.
Whoa. We got some Venmos. I got to give some love to the Venmo people real quick.
I'm going to say bye because I got to I'm only dressed from the top up. So I can't get changed until you're off anyway.
Are you saying you're naked?
No, I'm wearing my pajama pants.
All right. Hope said send 15 via Venmo saying, love the new photo of you guys. Exclamation points. Thank you. And then Kim, our daily Venmo angel. Happy Friday.
Thanks, Kim.
As always, send $25. And then we got Mary. Great stream. Thanks for all you do. Thanks for all you and Allie do. And that was 20 solid. Thank you so much, Mary. And then finally, GA Cat Mom herself sent 10 just because you guys are great. Oh, we love you guys. Mods, thank you so much. We're sorry to cut it short. The little Karen Read hearing. Plus, we were losing massive amount of people. You know, it's like Melanie went live with a 10-minute hearing and we lost 1,000 people.
That's
whatever.
All
All right. So we will definitely have part 2 in very, very short order. Make sure you're coming back because I'm not gonna lie. In terms of the kind of the petitioning activity, you're a little bit ahead of the curve on that one over here at Defense Stars, but you know, whatever. Who's counting what's what? Me. I always do. I'm always counting. All right, you guys, we love you. We love you, mods. You're the best in the business. We love you. Make sure you're going to Seeking Justice and their Discord channel. It's awesome. It's not only a document repository, it is now the place where you can play amazing trivia. Plus, they watch stuff on TV together and they all talk shit the whole time. It's amazing. And then to all members, new and old, we love you guys. And to you guys, the viewers that are with us in and out, if you're new, we love you. Welcome. Sub, please. It's free. We're trying to get over 70,000. We're at like, you can jump off. I thought you were coming up to get changed. Oh, yeah. In the time that it takes you to walk down the hall.
The sentence. Bye, guys. Love you.
All right. So whoa. We love you guys. And if you're on replay, make sure you leave a comment, please. And like, share, subscribe. All right, y'all. We love you guys so very much because without you, I'd just be an old man
sitting around talking to his wife.
Bye.